We are waiting for the tubes to connect themselves yet again. We're going to see if this works because I have reconnected a couple things and I don't know what's happening. So we're going to see if it works over on the YouTubes or what's going on. And so it's going to be a little bit of a rocky start. So we're going to have to take a quick minute to get our bearings straight, readjust the settings, but I want to see if we're working on the other platform, specifically on Rumble. Are we live there? Are we live there on Rumble? Seems like it's stable now, is what somebody is saying. How about now? Looks good on YouTube. Seems like it's stable now over on Rumble. Jeffrey Davidson says, I'm here on locals. Just getting in, hear you now. Good, we're good on YouTube is good. How is locals? Locals is good. All right, locals looks good. YouTube looks good. And we're back. All right, nothing like a good old reboot, says Mr. Man. Now we're having to figure this out because we just had a stream this morning and it was perfectly fine. There were no technical issues. I didn't touch a damn thing and then came back and then it's not working. So you know how it goes. So Rumble's good. We've got locals is good. Vientica says the stream needs more bacon. Okay, so now it's good. And now we can get into it. Sorry about the inconvenience, my friends. I'm going to have to get a new computer. Maybe Santa will bring me a new computer here. Ah, gosh. I got to upgrade this piece of junk, huh? All right, so we're good. Let's get Telegram up. Thank you, Nathan, for the reminder. We got to get Telegram back up. It's all discombobulating, you know, when you have to reschedule everything. So, all right, looks like Telegram's back up. Thanks for that. Okay, now we can go ahead and get started. So let's do it, shall we? As soon as we get this queued up again. It's all discombobulated. Not my finest open here, my friends. Not my finest open. You know, this is how it goes, though. All right, so we have now the tubes look like I blame Nikki Haley for this. Let's get started, my friends. Hold on, let's do it this way. And now we can get started. Hello, my friends, and welcome back to yet another episode of Watching the Watchers Live, the show that spotlights misconduct involving police, prosecutors, and politicians. My name is Robert Gouveia. I am a criminal defense attorney, and today we're talking about Donald Trump being in the Supreme Court and opposing Jack Smith's request to leapfrog the Court of Appeals. Remember, Trump is appealing his immunity issue, he's appealing his double jeopardy issue, and we're battling at the Supreme Court, and the left is wanting the Supreme Court to get Jack Smith's case back on track so that the trial can happen well in advance of the 2024 election. They need him convicted so that they can beat him at the ballot box. And so we're going to go through and see what the filings look like. First of all, Trump submitted a petition, a brief in opposition at the Supreme Court. And so we're going to read through that. It is about 40 pages long, but it is a single column, and so we'll be able to get through it quickly. We'll see what Jack Smith said in his reply, because he's urging the Supreme Court to accept this case. I mean, they really want Trump to be deviated from the election. And then we'll hear some reaction, not only from Conway, who I think really wanted a position in the Trump administration. He's going to come out. He's going to say, you know, our entire system is being threatened by this single man. This one person is going to wreck all of America. And Trump is going to come out on the heels of that conversation from the blood comment. He's going to say, you know, to be honest, America, I've never even read Mein Kampf, never even heard of it. So we're going to go through that one and see what he says there, all in the Supreme Court. Then a very interesting filing, man. And this one came from this guy. You may know him. His name is Edwin Meese, former Reagan Attorney General. And Reagan was, you know, a very good president here. And of course, Edwin Meese was his Attorney General. So he's the same guy. He's in the same position that Attorney General Merrick Garland is now. And Edwin Meese submitted a brief into the Supreme Court, making the argument that Jack Smith is not even allowed to be appointed here, that he was basically illegally appointed by Merrick Garland. He's not valid under the Appointments Clause. And so that the entire prosecution against Trump is actually invalid, unconstitutional. And so we're going to read through that brief in detail and see what's there. Now, CNN brought on some other experts to talk about this case, and they're saying that the courts are going to determine the fate here, and that CNN is a little bit nervous, like, maybe the Supreme Court is not going to find in the same way that the Colorado judges found. We've also got a clip from Jen Psaki. They're starting to hit the panic button a little bit. They're saying, what can we do if this is all going awry? I mean, if Americans keep supporting Donald Trump and he keeps going up in the polls, can we indict him again or something? And so we'll see what she says. And then we'll turn our attention over to Florida because Trump is objecting to Jack Smith's jury questionnaire. Jack Smith is filing a bunch of motions. He wants to get Trump convicted immediately. And he's now asking for a written jury questionnaire to go out in the Florida case. But Trump's defense says, no, we're not going to be playing that game. We don't want to do that. And so we'll go through both of those filings here today. We've also got a clip from Nikki Haley. She is completely burying her head in the sand as it relates to the Trump stuff, says, I don't want to know anything about his cases. I don't want to know anything about this hubbub. It's not my business. It's for the courts, which is wild because in my opinion, it's probably the biggest issue in the country. It's them literally taking your right to vote away from you. So the fact that she has that position, I think, is largely disqualifying. And then we'll see what Bill Barr has to say, because even Bill Barr is acknowledging that this is a bad decision out of Colorado. And so we'll go through all of that and more, my friends. We got 3 nice segments to attend to, and I am grateful that you are here and joining us as we go through them. This morning on our members only stream, we talked about the Washington Post basically calling it quits in Ukraine. They took the Ukraine tab off their homepage at the Washington Post, which means I think it's game over. It's like that the end of the war. Is that official now? I don't know. But we did talk about that with our members this morning. And if you want to be a member, you can join us at watchingthewatchers.locals.com. And so we are going to get into all of this and more, my friends, but we have a tremendous message and a message about safety on the internet, courtesy of our friends over at Private Internet Access. Do you have a VPN yet? It's important to stay protected on the internet, my friends, and Private Internet Access will help you do that. Private Internet Access is a VPN service that creates an encrypted tunnel for you when you browse the web so that people on the same network as you can't snoop in and see what you're doing. And that's awesome. But what I also love about a VPN is that it allows you to change your IP address to one of over 90 countries around the world. This lets you bypass geographic restrictions on certain websites like Netflix that will often limit movies or TV shows like one of my favorites, The Office, and they do that based on your region, meaning that when you change your region, you get access to additional content you might not otherwise see. PIA also gets you around website geo restrictions. For example, Canadians now can't access Facebook News and Google News, the controversial BC-18 bill, but with PIA, they can. And what I like most about Private Internet Access is that they are the world's most transparent VPN provider. With over 30 million downloads and a no logs policy means they never record or store user data. All this has been verified by a third-party audit from Deloitte and successfully defended in court in litigation. And now, Private Internet Access allows you to protect all your devices with just one subscription so you can protect your whole household in one go. Super simple. So let's get you a VPN from Private Internet Access. Go to www.piavpn.com/Robert and you'll get 83% off and 4 months free when you sign up for a 2-year plan. Be sure to use my link for a major discount on this initial offer, and my friends, we'll see you at piavpn.com/Robert. All right, my friends. So as you can see, Private Internet Access is a good solution, and thank you for supporting the sponsors on the show by going to piavpn.com/Robert. The link is in the description below. Okay, now we are going to jump right into it without any further ado, because we've got some serious Supreme Court briefs to read through, starting with this one. Donald Trump submits his brief opposing Jack Smith's attempt to leapfrog the Court of Appeals and take this case right to the Supreme Court. The reason why Jack is going so fast is because this is the January 6th case, and he wants this trial to go on March 4th Even though everything has been paused while this is on appeal, Jack Smith wants it to get resolved very quickly. And so we've already read through Jack Smith's original petition to the Supreme Court saying, can you please leapfrog the Court of Appeals? But now Trump is filing his brief in opposition. Jack Smith is going to reply on top of that. Remember, he's going to get the last word, and we're going to hear a reaction from Conway and from Trump himself. But diving right into Trump's brief, here is what the defense team for the former president are arguing in the Supreme Court of the United States. The case is United States versus Donald Trump, and this is Trump's brief in opposition to the petition before the court. You know, it's the usual suspects here. We've got John Lauro and Todd Blanche, who are both writing on behalf of Trump. Now, here are the questions that are being presented. Now, they're concerned, actually, that Jack Smith's question is not accurate. So Jack Smith, when he submits his petition to the Supreme Court, he is posing a question. And what they say, starting out, is they say, guess what? Jack Smith's proposed question, it misstates the issue. It's totally wrong. It misstates the legal issue in this appeal by incorrectly framing it as whether there is absolute presidential immunity to crimes committed while in office. Okay, and we called that out from day one. Like, we didn't say that the president could commit crimes. It's immune from prosecution for official acts, one of which is making sure that elections are legitimate. Okay, so every time you hear one of the lefties screaming about, I guess Donald Trump can just execute the vice president then, if this stands. I guess he can just commit insurrection whenever he wants. If you're a smooth brain like Ted Lieu, who says that maybe that means Joe Biden can just seize power for indefinite lengths of time, that's all not what Trump's argument is, okay? The actual issue is about immunity for official acts, one of which is making sure elections are conducted appropriately because he's the chief executive of the country. It's their job. So the question is whether the doctrine of absolute presidential immunity includes immunity from criminal prosecution of the president's official acts, even if those official acts are within the outer perimeter. That's the question, they say, not Jack's interpretation. And the next question is whether the Constitution and double jeopardy, the principles there, would foreclose a president who's already been impeached and acquitted from being someone who faces criminal charges. And so those are the two questions. And they say Jack Smith really got this all wrong. They say these are the related proceedings. Here is our table of contents and our table of authorities that we'll fast forward through. And they're going to take us right to the opinion. They say, guess what, Supreme Court? All 9 of you? This case presents a fundamental question at the heart of our democracy. Very simple, whether a president may be criminally prosecuted for his official acts. Now, this calls for this to be resolved in a very cautious, very deliberative manner, not at a breakneck speed. Okay, Jack Smith wants to go fast because he needs the conviction before March, before the election. He wants the trial to start in March. But in 234 years of American history, no president, not one, has ever faced criminal prosecution for his official acts. Now, until 19 days ago, no court had ever addressed whether immunity from such prosecution even exists. But to this day, no appellate court has even addressed it at all. And so the question stands in front of us. It's one of the most complex, intricate, and momentous decisions that this court will ever be called upon to decide. Now, we have a normal appellate process for a reason. They say this court's ordinary review procedures, just allowing it to go regularly, will allow the district court to address this appeal in the first instance, thus granting this court the benefit of an appellate court's prior consideration of the historic topics and doing the traditional winnowing function that the court has preferred. Like, you got to go through the classes, right? Like, you can't just go play pro football. You got to work your way up. Indeed, the D.C. Circuit has already granted highly expedited review of this, and we've already had oral arguments. And so they say, hey, SCOTUS, Jack Smith is urging this court to bypass all of these ordinary procedures. We have a long-standing preference for prior consideration, and this court should decline this invitation to leapfrog over the rest of the case. And why? Well, we've got a couple reasons. They say, first, the government lacks Article 3 and prudential standing to appeal from a district court judgment. Now, you can't just do this. The government is not injured by this decision. This case doesn't fall within the narrow class of cases where they're allowed to do that, and so you can't allow it. And second, prudential considerations also weigh heavily in favor of this. Allow the D.C. Circuit to address this case. It's already at the Court of Appeals. And so here they say, in fact, right now it's already rapidly underway. The D.C. Circuit has already expedited this and we're already scheduled for briefs. So Trump is saying we're already going to argue about this, okay? January 2nd and oral arguments on January 9th. So you don't need to come in front of the process. And this makes sense because Trump wants this to go slow. It makes absolute sense. And if I were representing him, I'd also want it to go slow because it's very important stuff. You don't need to accelerate everything. Now, third, they say, Jack Smith also identifies no compelling reason for the extraordinary haste that he proposes. He says in some vague assertion that public interest favors a resolution and that we need a dramatically increased timetable. He is confused, though. What he's doing is he's confusing public interest, which he thinks is nonpartisan, with his manifest partisan interest in ensuring that Trump is going to be subjected to a months-long criminal trial at the heights of a presidential campaign. The combination of an almost 3-year wait to bring this case demands that we give us the same amount of time to investigate. And fourth, they say the law that special counsel supports does not even support this request here in front of the Supreme Court. In Nixon, there had been extensive and thoughtful consideration of presidential privilege. We had multiple appellate decisions. It took 2 centuries between those things to get to the conclusion. But here, in Trump's case, that's not happening. The sum total of judicial grappling with this issue is on a 19-day-old district court opinion. That's all. Chutkan issued opinion, we've had an appeal, and we're just hashing through it right now. This history counsels in favor of allowing the D.C. Circuit to address this first, and then we'll get to the Supreme Court. And fifth, the ruling below was issued 9 days after a close of briefing because the special counsel wants this done quickly. But the result, no, was bad. It was a hasty analysis of complex issues, and it overlooks the binding authority elsewhere. And so every jurisdiction here needs to consider this, and this case needs to appeal first to the D.C. Circuit Court of Appeals, which is where it is right now, saying haste makes waste. It's an old adage. It survived because it's right. Now, briefly, we'll just take a look at this jurisdictional statement, but they say, first of all, this court doesn't even lack jurisdiction, doesn't even have jurisdiction over this case, okay? Article 3, it says this court grants cert, which is what Jack Smith is asking for. When it grants cert, we don't want it to act as the Court of Appeals. A party seeking judgment before the lower level court must have standing to appeal the decision. But in rare instances, the Supreme Court may grant a petition to the prevailing party, but they've got to be able to really come up with an injury that they can address. In cases where a prevailing party standing to appeal a favorable decision has been recognized, the ruling challenged on appeal decided against that party in a way that inflicted an ongoing injury to the party. And so, thus, an official whose conduct is deemed unconstitutional but is granted immunity suffers an ongoing injury from the decision, which is a de facto restriction on their freedom. And saying, so that's not the case here. Here, the district court denied Trump's claim of immunity and double jeopardy in total. So you can't separate things out, wrongfully holding that there is no presidential immunity and saying that Trump can be prosecuted. And so the judgment here is broad enough. Everything gets paused and we have to appeal it. So the only injury that special counsel asserts in this appeal is just the delay of the trial date. So there's nothing else you need to consider. The government may be injured by Trump's appeal, but it's not injured by the district court's judgment. And the judgment is what is being appealed. Okay, like the government is different than the judgment. And the government is very upset about this. Like, we know they want Trump convicted immediately. But that's not alone a basis for expediting this. Like, that's just because you're mad doesn't mean you get to go to the Supreme Court. Now, moreover, even if the court had jurisdiction, which it does not, the court should not exercise it here. Okay, we want it to go through the Court of Appeals because that's the proper mechanism to do it. Now, in the rest of their statement, now that they say the court doesn't even have jurisdiction now, they're going to get into the meat and potatoes. They say, this indictment alleges purely official acts. It's not criminal conduct. Okay, the idea that Joe Biden wouldn't leave office would be a new criminal act. Okay, Trump left office. They say on August 1st, President Trump was indicted. We know the background. But the indictment does not charge President Trump with any responsibility for January 6th. No. Instead, it talks about his political speech. It talks about his advocacy. The indictment alleges 5 types of conduct. We know what they are. Okay, the first one is Trump made a series of tweets. Then Trump communicated with acting attorney general. Then Trump talked to state officials about their elections. And then Trump talked with Mike Pence about the election. And then there were alternate electors. We got all of that. Now, all of those things, they say, is legitimate. Okay, those are his official duties. And that's what Trump does, okay, is he makes sure that the country is working. That's what he does. You go around to different states. How are things going? How can the federal government support you? Blah, blah, blah. So in addition to all of those, right, every single one of those was an official act, all within the purview of the executive branch, because you got to make sure the country runs elections. Now, Trump, they're saying, also has a basis for dismissal. He also submitted 2 motions to dismiss based on the immunity issue and motion to dismiss based on double jeopardy. They say here, Trump filed those and he made his points. They say, first of all, presidential immunity is rooted in separation of powers, okay? The president occupies a unique position in the constitutional scheme, and he is basically the root of the Constitution. Now, under our separated powers, neither a federal court nor a state prosecutor may judge a president's official acts. Those are his acts. And if he's allowed to do his acts, you can't insert your opinion about those acts, Liz Cheney. Likewise, no court or federal court has jurisdiction to sit in criminal judgment over them. Okay, you may not like what Trump said or did, but you're not allowed to make judgments on them. Otherwise, there is a problem with separation of powers. And second, they say President Trump argued that the impeachment clause presupposes that the president is immune. Why? Because the party convicted shall nevertheless be liable if you are impeached and convicted, right? You got to get impeached in the Senate, which Trump was. Then you got to be convicted. You got to be impeached in the House, which Trump was. And then you have to be convicted in the Senate, which Trump was not. And so here they say that immunizes him, essentially. And so third, President Trump also cited evidence about this. He explained specifically, Alexander Hamilton wrote that the criminal prosecution of a president may occur after the impeachment and the conviction. Otherwise, various prosecutors all throughout America can just decide that they want to go take out a president and then indict him, as we're seeing happen right now. So they say fourth, in another case, immunity decisions have come from common law. And fifth, we have a history, a 234-year history of not prosecuting presidents for official acts. American history abounds with examples of other presidents who were accused by their political opponents of committing crimes. For example, John Quincy Adams said that there was a corrupt bargain by appointing Henry Clay as Secretary of State. And George Bush lied to all of us when he said that there were weapons of mass destruction there. Got us into a multi-year war, decades, thousands of good Americans dead, and trillions of dollars wasted into oblivion because he lied to us. Obama took out and killed a U.S. citizen, by the way. Talk about an insurrection. He killed his teenage son, too, also a U.S. citizen. Both of those were located abroad, among many other examples. And so those are all lies, okay? People are accusing their opponents of committing crimes all the time. But each one of those were vehemently denied. But no president was ever prosecuted until this year. Of course, it's Donald Trump. So that's what they do. Now, the unbroken tradition of not exercising the power of prosecuting a president over centuries implies that the power does not exist, okay? If they could have prosecuted each other, you think they would have? But they didn't. Now, six, they say Trump pointed to analogous immunity doctrines for legislatures and judges, and they say that courts have recognized other types of immunity. We've got civil immunity, we've got judicial immunity, we've got all other types of political immunity, but not for the president? That doesn't make any sense. And seventh, Trump noted public policy also would prohibit this. The prospect of allowing prosecutions to be brought against somebody just because they don't like their politics is not good for America. Now, Trump made these arguments, and Trump filed a motion to dismiss based on these grounds, and all of this stuff is now working its way through the courts. And so Supreme Court, they say, here's some more background. We also know that there's a double jeopardy argument. Trump made this argument, and it all worked its way through the courts, and now we are here. Continuing, saying, here are some reasons why you should deny this. First of all, this court's Rule 11 provides that a petition for cert before judgment will only be granted if there is imperative public importance that justify a deviation. So Jack Smith would certainly say there is, but Trump would say no. He said we can just go through the ordinary course of things. Now they say that prudential consideration should be taken. Okay, this judgment, what Jack Smith wants is extraordinary acceleration of this proceeding, but we don't need that. Here, Jack Smith urges, he says, no courts of appeals should be allowed to explore the questions before this court grants certiorari. But Jack Smith is incorrect. Issuing a writ before judgment has the possibility of creating splintered decisions. And so we don't want the courts to have that, we don't want, it's order of operations, right? You got to do your equations in sequence. And so they say Jack Smith, though, okay, the only justification for this is because he says it involves questions of extraordinary importance. He said, this case presents a fundamental question at the heart of our democracy that only this court can resolve. But he says, no, this is not right. Trump's defense continues, saying, but the importance issue here does not automatically necessitate speed. If anything, the opposite is true. Important stuff you slow down on. Novel, complex, sensitive, and historic issues like the existence of presidential immunity is very important, and we need to slow down. Saying, indeed, the fact that this case arises in a vortex of other political disputes warrants caution. We're in the middle of an election. So we don't need to go fast, especially when things are moving too quickly. So this case is both great and it's hard, which means we have to be deliberative. But that's not what Jack Smith wants. He says we should depart from these principles. Why? Because of the public interest. But he wants a compressed briefing. He wants something that is very difficult to get through quickly. In fact, he wants to move as expeditiously as possible. He demands an immediate resolution. He demands an appropriate timetable. But the problem with Jack Smith is he never explains why. Why do we need that? That date has no significance. Why do we need March 4th? In criminal law, it's not even important. The date has no significance. The prospect that an interlocutory appeal might affect the pending trial date, though, is the thing that matters. They're only concerned about trial date because of the election, not because it has any other importance. They say Jack Smith creates an appearance of a partisan motivation. If there is no other extraordinary reason to do this, then we know what the real reason is. It's because President Biden is facing a threat from Donald Trump, saying the current potential trial date falls the day before Super Tuesday, one of the most critical dates on the Republican calendar. And this is right when they want the trial to start. This is all being brought to light because Jack Smith wants to get rid of Trump. And saying here, he confuses what he calls public interest with partisan interest. And this echoes other incidents. Saying here, the Biden administration is doing this, according to Biden, for the good of the country. And millions of American voters certainly disagree. So we cannot allow Jack Smith to politicize the trial schedule here. And Jack Smith is threatening to tarnish this court's procedures. He's trying to drag the Supreme Court into the middle of this. And so the special counsel seeks to compare this case to another handful of cases, but those cases are all irrelevant. And he explains why each one of those is bad. In Texas, that's wrong. Commerce is wrong. But if we accelerate this, we're going to have hasty decision-making hazards. Saying the government wants a highly expedited resolution of this case. They want 9 days of deliberation, but this is a problem. This is moving at breakneck speed, and this is filled with deficiencies. First, the court has emphasized that no court has ever accepted the doctrine of criminal immunity. And the district court held that there was no such immunity that exists. So these are major, major issues. And third, we also know that Alexander Hamilton, which was already cited, said that this was inappropriate and that the judge found some other incorrect findings in her analysis as Chutkan carried on. And so as you can see, they're concluding this for us. They're saying the indictment of Trump fits this bill and it needs to be postponed, writing that for the reasons discussed, even if this court grants certiorari, which it should not, we would require a briefing on this and it's going to take a lot of time. And so, Your Honors, in other words, long story short, do not accept this case right now. You don't have jurisdiction. It's not fully ripe yet. We still need to go through the Court of Appeals and figure out what is actually happening there and just go through the regular procedure. Okay, Jack Smith wants to go fast, but there's no reason to do that here. So Jack Smith submitted his reply, and that's what this one looks like here. So in the reply, Jack Smith responds. He says, oh, no, we actually do need to go fast. So this is from the deranged thugs there at the special counsel's office. They say, Your Honors, sorry, we do need to go fast, saying respondents, Trump, or us, actually, we agree that the question is whether the issue is about conspiracy to overturn an election and prevent a lawful winner from taking office. And so they're disagreeing again with the framing of this. They say that's incorrect. This court is the only way to achieve a timely and definitive resolution, saying we agree this is a very important case, but we don't need to wait. The waiting suggestion, the charges here, they say, right? It's the charges. That's what's most important. It's the utmost gravity here. This case involves, for the first time ever, criminal charges against a former president, and not just any actions, in actions allegedly to install himself as the leader of the country permanently. And so they say their other arguments provide no sound reason to deny immediate review. He says the government lacks standing, but we don't think that. This case does warrant the Supreme Court hearing. There was serious criminal conduct, fraud against the United States, obstructing Congress, and blah, 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 right? We're familiar with all of that. Saying more than a century ago, this court, in considering this, gave a lot of concern to this back during the Civil War, and that the judgment here before the lower level court is appropriate, saying Chutkan's grant of the motion to expedite the appeal, the circuit court, the Court of Appeals, they expedited this. The briefing schedule is moving quickly. And so basically we're going to be done with this. And then we're going to be probably coming up to the Supreme Court. So you guys better be ready for it anyways. Writing, this court granting cert is in alignment with other historical context, like the Nixon case, and the stakes are just as high as what you did in Nixon. This case implicates a constitutional bedrock across America, and this court needs to resolve this before we can move forward. Trump's arguments lack merit, and any other briefings here are irrelevant. And so they tell us, for the foregoing reasons, you need to grant this right now because we got to get this resolved. And again, they didn't really talk about the election. I didn't see much in here about why the urgency is so important. I guess it's just the severity of the charges is really what we're seeing. He's got to stay of the proceedings. There are ongoing interests to dispute. And I guess the country just needs a resolution, right? So that's Jack Smith's response. And then we'll see what the Supreme Court says about this in really about whether even to just accept the case. So they're not going to give us a decision yet about whether Trump has immunity or double jeopardy or those things, just about whether it even gets accepted. And so we'll be waiting to see what happens. Jack Smith wants it there, and others certainly want it there too, because they want the Supreme Court to kick it back down to Chutkan and have her put the trial back on track. Now, this is George Conway, who is saying this is a big problem. You know, if the courts don't find in our favor, our entire system is going to be at stake here. And this is what he said. You know, this is the first time I ever voted for a Democrat. Why? Because our whole system is being threatened. And he was hanging out with Morning Joe and Mika. And here's what these two sounded like.
Didn't codify Roe v. Wade. Joe Biden didn't stop my gas prices from going up. So I don't really care what Donald Trump's saying, whether he's quoting Hitler or not. I just want my prices to go down. Yeah, so what do you say to that person?
Yeah. None of that matters compared to what's at stake at in this election. And Joe, more to your point, I'm 60 years old. I first voted in a presidential election in 1984. I voted in 10 presidential elections. 2020 was the first time I ever voted for somebody other than the Republican. First time I ever voted for a Democrat for president. And the reason is because our entire system is threatened by this one man and his supporters. None of these things that you talk about, none of these matter if a president can declare himself president for life and can call out the army and under the Insurrection Act to arrest whoever he wants, to shut down the media. And this is exactly what he wants to do. If he's elected in 2024, I don't know that he will be able to do all of those things, but he will try. And the fact that he tries will cause great damage, as he did over 4 years to this country. It will cause great damage to this country. It will paralyze the government and will cause civil unrest, and we will lose our democracy in the way that other countries have lost their democracies by disorder and chaos. And we can't allow that to happen.
We can't allow that to happen. And so they're going to do everything they can. Keep him off the ballot, indict him multiple times, call him a racist, meltdown over the blood comments. And really, I mean, the language is getting pretty bad, saying that he's like Hitler, or he's like a Confederate and so on. And so they're really, panic level 10, hitting the nervous button over there. Meanwhile, Trump doesn't even know what Mein Kampf is. Here's what he says. I never even read that stupid book. Here's Trump.
They come from Africa. They come from Asia. They come from South America, but not just South America. They're all over the world. They dump them on the border and they pour into our country, and nobody's there to check them. And the Border Patrol is incredible, by the way. They want to do it, but they're told not to do their job. It's crazy what's going on. They're ruining our country, and it's true. They're destroying the blood of our country. That's what they're doing. They're destroying our country. They don't like it when I said that. And I never read Mein Kampf. They said, oh, Hitler said that in a much different way. No, they're coming from all over the world, people all over the world. We have no idea. They could be healthy. They could be very unhealthy. They could bring in disease that's going to catch on in our country, but they do bring in crime. But they have them coming from all over the world, and they're destroying the blood of our country. They're destroying the fabric of our country.
There, right?
They come from Africa.
And that is where we were explaining that this is the body politique metaphor, right? The state of a nation. What does the body politique look like? Is it a healthy body or not? Right? It's the idea that crime and disorder and garbage and, yes, other things like fentanyl that might actually go into the blood are all problematic. That is what Trump is saying. But those people, I guess they want more chaos at the border. They don't think the entire system is threatened. It's wild to think this. Like, they think the system is, I think, in perfect shape. And then if Trump wins, it's going to be in disarray. I mean, do they realize we've got like multiple wars breaking out across the world? We've got a currency that is totally, in disrepair. We've got a border that's wide open. But these people are concerned about Trump. It's like their guy has caused all of this wreckage. But Trump is now battling at the Supreme Court. We're going to be here to see what the Supreme Court says. Of course, they're going to issue a ruling on this. And we'll look forward to seeing what it is at some point. We do believe the Supreme Court is going to weigh in on this, but do they need to do it on this issue right now? Or maybe Jack Smith can just appeal it after the Court of Appeals. We'll see. We'll be covering, my friends. Thank you for subscribing. Thank you for liking this video, and also going to robertgovea.com to sign up for our daily newsletter. And if you want to read or access any of the PDFs, they are on at robertgovea.com. And we'll look forward to seeing you back here on the next one. All right, my friends. Now, let's get into this story. Now, I've gotten several emails on this story, a lot of curiosity about this one, and I'm excited to get into it. So let's do it. Jack Smith is illegal. His appointment is invalid. That's according to a former attorney general, the leader of the Justice Department under Ronald Reagan. His name is Edwin Meese, and he has submitted an amicus brief along with some other law professors, up to the Supreme Court of the United States. And what he is saying is that Jack Smith is not validly appointed to investigate this. Okay, Merrick Garland used the wrong statutes under the Appointment Clause, and he tried to rig this thing, as they usually do, and it's invalid, saying that the entire prosecution needs to be dismissed. We're going to get reaction to this and other conversations from Caitlin Collins on CNN. They're saying the courts are going to determine the fate here and that maybe this is not going to go in their favor. And Jen Psaki's freaked, man. What can we do? I don't know, Jen. Maybe you should indict him again. Good move. So let's take a look at the filing. This is what it looks like. And let's get our big, beautiful red pen out and ready to go. In the Supreme Court of the United States, the case is United States versus Donald Trump, submitted by former Reagan Attorney General Edwin Meese. He says, guess what? We say that Jack Smith is illegal. This is an amici, so it's a brief from some law professors called Stephen G. Galbraith, Gary Lawson, supporting neither party, just saying, hey, SCOTUS, by the way, Jack Smith is invalid. Here's the question. Dear Supreme Court, from the former Attorney General under Reagan, smart guy, question whether private citizen Jack Smith lacks authority to represent the United States, which jurisdictional requirement must exist at all stages of litigation and which cannot be waived in filing his petition for a writ of certiorari with the court. So can a private citizen, Jack Smith, who doesn't have any authority to be on this case, can he submit a brief just out of nowhere? Like an illegally appointed prosecutor is basically what this is asking. Can an illegally appointed prosecutor just file a brief about Trump to the Supreme Court? They're going to say no. Here's the table of contents. We'll fast forward through. Here is the table of authorities citing their research along with the constitutional provisions. And here's what they say to the court. Arguing that Jack Smith has been illegally appointed, they say, guess what, SCOTUS? This court should reject Mr. Smith's request for certiorari for access to you guys for the simple reason that he lacks the authority to ask for it. What's he even doing here? Who let him in the building? Nor does Jack Smith have authority to conduct the underlying prosecution. Oh my goodness. The entire ordeal needs to be thrown out? Says those actions can only be taken by persons who are properly appointed as federal officers to properly created federal offices. Neither Smith nor the position of special counsel under which he purportedly acts meets those criteria. And that's a serious problem for the rule of law here in America. Whatever one may think of Trump or the conduct here, you got to have an actual prosecutor. Now, how did this illegality start? How did these people squeeze this one by? Well, they tell us the illegality addressed in this brief started back on November 18th. That's when Merrick Garland, the current Attorney General, who's doing a much worse job than I did, when he exceeded his statutory and constitutional authority and he allegedly purported to appoint Jack Smith to serve as the DOJ. He said that he was the special counsel. Now, Smith was then appointed, quote, to do the following: to conduct the ongoing investigation into whether any person or entity, including Trump, violated the law in connection with the efforts to interfere with the lawful transfer of power during the January 6th event. Okay. And he says, look, if you want to read that, easy, just go get it. You can see what happened. Okay. Merrick Garland put in a writing, right? I'm Merrick Garland, and by order of this, I appoint Jack Smith special counsel. We read it here. Now he says, no counsel for any party authored in whole got any monetary contribution towards this. He said, okay, we're just filing this, law professors and the former AG. He says Attorney General Garland then, after that appointment, in that letter, he cited these four provisions of U.S. Code, 509, 510, 515, 533. He says, those are my authority. I get to use that law to appoint Jack Smith. But what Meese says, and these law professors, but none of those statutes nor any other statutory or constitutional provisions even remotely authorized the appointment by the Attorney General of a private citizen to receive extraordinary criminal law enforcement power under the title of Special Counsel. Like, they just pulled Jack Smith from that pod over there in Klaus Schwab's International Criminal Court, and they brought him over here. They just inserted the TDS chip, which was already there. They just elevated it. Just let's pull that up to 11. Okay, now you're appointed. And they said, okay, well, here's why. First, the Appointments Clause of the Constitution requires that all federal offices that are not otherwise, quote, provided for, a catch-all exception, that are in the Constitution, all federal appointments must, quote, be established by law. That's in the Constitution. And there is no statute establishing the office of the Special Counsel in the DOJ. That statutory provision relied upon by the DOJ and lower courts for the appointment of special counsels over the past half century do not authorize the creation and the appointment of special counsels at the level of U.S. attorneys. Okay, so he's saying basically 50 years of this law is bad. The provisions that the DOJ is relying upon to create these offices doesn't allow them to do that. And by the way, Nixon does not hold to the contrary, because no question was ever raised in that case about the validity of the independent counsel's appointment. Okay, so basically, like, the DOJ has just been creating these things and everybody's just been allowing them to happen for years, but nobody's ever actually done the analysis. So Merrick Garland just got the template out of the DOJ file and said, we'll just use 509, 510, 515, 533, but none of that gives them the authority to actually do it. Now, that case concerned the relationship between the president and the DOJ as an institution, not between the president and any specific actor purportedly appointed by the DOJ. So Jack Smith's case is a little bit different. And so, in other words, Nixon doesn't waive this, okay? Like, the Supreme Court didn't impliedly authorize this by just accepting it. He says it wasn't even an issue in that case. Now, second, even if one overlooks the absence of statutory authority for that position, there is no statute specifically authorizing the Attorney General rather than the President by and with the advice of consent of the Senate to appoint a special counsel. There's no law. Under the Appointments Clause, which is the Constitution, inferior offices, and so if there is no law, you have to revert back to the Constitution. Unless Congress said that the DOJ can do this, you can't. Because under Appointments Clause, which is now the really governing law, they say inferior officers can be appointed, so somebody like Jack Smith, can be appointed by department heads only if Congress says they can, by statute. And you can go to the Constitution to look at that. And it directs specifically enough to overcome a clear statement in presumption in favor of a presidential appointment and senatorial confirmation. So the Appointments Clause says that, and so directs specifically enough to overcome a presumption, right? The Constitution wants presidential appointments and senatorial confirmation. But the DOJ just said, well, we can just kind of appoint our own special counsels that are not the Attorney General, right? He says, but no such statute exists for the special counsel. And third, the special counsel, if he was considered a valid officer, is a superior or a principal rather than an inferior officer, since he's at the top of the list. And thus he cannot be appointed by any means other than presidential appointment and senatorial confirmation, regardless of what any of the other statutes purport to say. The special counsel is not an inferior officer. He's head, so-called, of kind of a separate entity. Now, this is true as a matter of not only the original meeting, but it's even true as a matter of law once understands that neither of those cases can plausibly be read that any person who is in any fashion subordinate to another executive official other than the president is an inferior officer. Such a reading of those decisions would lead to a ludicrous result that there is only one non-inferior officer in every executive department. So they say, to be sure, there are times when the appointment of a special counsel is appropriate. Okay, so we can do this, but the statutes and the Constitution provides the means for those appointments by allowing the use of existing state attorneys, okay, existing U.S. attorneys. Any number of U.S. attorneys have performed with distinction the function of serving as special counsel. Okay, so for example, on December 30th, this guy, Patrick Fitzgerald, he was the U.S. attorney for Illinois. He was lawfully appointed by the attorney general. That guy investigated the Valerie Plame leak affair under Bush Cheney, which arose within the jurisdiction of the district court. Fitzgerald, who was a Senate-confirmed officer of the United States, then prosecuted and secured the conviction of Dick Cheney's chief of staff called Scooter Libby. That was in the U.S. District Court for Columbia. So you see what happened? They went out and they picked out an already existing U.S. attorney who's already in the government, right? Already, appointed and approved by kind of the structure there. Another example involved another Senate-confirmed U.S. attorney. You remember the name Rod Rosenstein, John Huber, John Durham, all Senate-appointed special counsels. Now, all of these investigations and prosecutions of high-level wrongdoing were lawful. So, yeah, special counsels are great. We can do those. That's fine. No problem at all. But you got to pick a U.S. attorney. You can't just pick some citizen from overseas. Now, what federal statutes and the Constitution do not allow, however, is for the Attorney General, Merrick Garland, to appoint a private citizen called Jack Smith, who has never been confirmed by the Senate, as a substitute U.S. attorney under the title Special Counsel, right? They just want to just go find somebody. Yeah, this guy's a deranged thug. He'll fit the bill. Come on in, Jack. Oh, your wife loves Obama? Great, love her too. Now, that is what happened on November 18th. Merrick Garland went and got him. That appointment was unlawful, as are all the legal actions that have flowed from it, including Citizen Smith's current attempt to obtain a ruling from this court. He has no power here because he is not a U.S. attorney lawfully authorized under the law. Saying, given their interest in the rule of law, the legal issue addressed in this brief is of particular importance to amici. The Honorable Edwin Meese, 3, served as the 75th Attorney General, did a much better job under Ronald Reagan. Shout out to Meese. And he says, throughout our history, he's also a distinguished fellow emeritus at the Heritage Foundation, and his tenure as Attorney General throughout all of this time, he defended proper limits on the federal government. And these law professors are doing the same thing. Shout out to Professors Calabresi and Lawson. Shout out. They're scholars of the original meaning of the Constitution, which we appreciate, and saying members of this court have cited their work in the past. And you can take a look. Gorsuch cited Lawson. All right. Thanks for that. Justice Thomas cited Calabresi. Thanks for that. That's fun legal drafting right there. Oh, you guys know who these law professors are, don't you? You do, Thomas, because you cited Calabresi, and Gorsuch, you cited Lawson. So you know who they are. So they say, all right, with that backdrop here, these are the reasons for denying the petition, Supreme Court. First of all, no statute authorizes the position of special counsel that Jack Smith is seated in. He's got a stolen chair. In our constitutional system, Congress alone has the authority to create federal offices not already established by the Constitution. And the Attorney General cannot ex nihilo fashion offices as he sees fit. Just create his own special counsel because Merrick Garland hates Trump. Nor has Congress given the Attorney General power to appoint a special counsel of this nature. And so, thus, without a legal office, Smith cannot wield the authority of the United States. He doesn't have an office, including his present attempt to try to seek relief in the Supreme Court. Who is this guy? Only Congress can create a federal office, not Merrick Garland. The Constitution itself creates no executive positions other than the presidency and the vice presidency, if one considers that an executive position. Instead, the Constitution commits the power to create the federal offices to Congress. under the necessary and proper clause. It says Congress has the power to make, quote, all laws which shall be necessary and proper for the carrying into execution the foregoing powers and all other powers vested by this Constitution in the government or any other department thereof. Okay, so Congress gets to do that. But they didn't appoint Jack Smith. Garland did. A law creating offices to carry out the executive function is the quintessential law of Congress. And that means that Congress has the exclusive constitutional power to create that office. So what is Jack Smith doing? So here they tell us, Kagan was even dissenting in that opinion. But they say if you go through that analysis, the Constitution does not give the president or the heads of the executive departments the power to create any offices or to appoint any officers that they deem appropriate. No. Instead, it requires that Congress first create all offices to which federal officers, superior and inferior, can be appointed. Okay? They usurped Congress. Now, they say this is confirmed by the Appointments Clause. You can read this in the Constitution. They tell us it provides that the appointment of officers which, quote, which shall be established by law, capital, law. Article 2, saying that the addition of the emphasized phrase in the Appointments Clause was deliberate. How do we know that? Well, on September 15, 1787, after, quote, officers of the U.S. whose appointments are not otherwise provided for, were added the words, and which shall be established by law. Okay, so these two law professors, they wrote a law review article. It's called The Records of the Federal Convention, 1787. Probably an awesome read, if I had to guess. But it says that they were chronicling this, like they were chronicling the federal constitutional convention. What were they doing when they were drafting this Constitution? Well, on September 15th, after they inserted that phrase, they also inserted this phrase, which shall be established by law. Okay, so Congress has to do it. Now, this addition's plain import is that the word law establishes that the office must be a statute. You don't just have somebody who just says, oh, we're going to have 35 offices now because I got elected. No, we want some limitations on that, some limiting principles. A regulation or executive or judicial order is not the kind of law that can create an office under the Appointments Clause. So there's no, executive order that just goes and appoints this. It's not Merrick Garland just deciding so. You need a law. Now, indeed, they say, the Constitution consistently uses the term law and laws, and when otherwise unqualified, we know that that means statutes, which come from Congress. So if no statute establishes an office, if Congress doesn't establish it, there is no office to which someone can be appointed. Now, the organic statutes of the Department of Justice that they just created do not by law vest in their powers the ability to appoint someone like this. The DOJ's current structure, which is provided by the law, by statute, includes the following. If you read the rules, it says they get, at the DOJ, you get one AG, you get one which is Merrick Garland, you get one deputy AG, which is Lisa Monaco. You also get an associate AG, you get solicitor generals, you get 11 assistant attorney generals, you get one U.S. attorney for each judicial district, which is currently 94. So you have the U.S. attorney for the state, and then you have all of the other U.S. attorneys who work there. You get a director of the FBI. You get a director of the marshals. You get one U.S. marshal for each judicial district. You get a director of ATF. You get a director of the Bureau of Prisons. You get 21 U.S. trustees and as many United States attorneys and, quote, special attorneys as the Attorney General deems necessary. Okay, that's it. That's the list. Now, this list does not include more than 100,000 people, gross, who work in the DOJ. The vast majority of federal workers, including those who work at the DOJ, are not, quote, officers of the United States. They're employees whose appointments are not controlled by the Appointments Clause and who therefore do not require any specific statutory authorization. For their appointments, it suffices to provide, as Congress has done that, quote, each executive agency, so Congress wrote this into a statute. They said that each executive agency, military department, and government of the District of Columbia may employ such number of employees in the statute of the various classes recognized under the law. But officer positions must specifically be established by law, and employees cannot exercise the powers of officers. To be clear about this and to be sure, they also tell us that the Ethics in Government Act, which was passed in 1978, they added to the mix what they called an independent counsel, right? So they wrote this into the rule. That was appointed, an independent counsel would be appointed by a special 3-judge court upon a referral by the Attorney General. That didn't happen here in Jack Smith's case, not at all. So he was not an independent counsel, okay? And so you've seen this come up here on this channel when somebody else will come up and say, like Caitlin Collins from CNN, you know, he's independent, he's non-biased because he's appointed as a special counsel. Obviously, that's not true, okay? He's not an independent counsel, which is what she was thinking, you know, when she said that. And I think it was Trump's former lawyer who kind of corrected her on that and said, no, there was no independent counsel, Caitlin. You are thinking about this wrong. Jack Smith is a partisan hack, appointed by a partisan hack. There was no, Congress didn't approve him. Nobody gave it to an independent group of judges who said Jack Smith's great for this. He wasn't working for the Department of Justice previously. They just went and picked him up. But the statutory provisions for the independent counsel expired back in 1999, and Congress didn't reauthorize them. But shortly before that expiration, then Attorney General Janet Reno promulgated regulations which, if valid, are still in force today. And so Janet Reno said that there was an office of the special counsel. She just created it. She just created regulations, okay? She created the Code of Federal Regulations, and she just made this up, Office of the Special Counsel. But that's not what the law says. He already told us what you can have. There is no Office of the Special Counsel here. They do get some special attorneys, whatever that is. Let's see. So here, under these regulations, Janet Reno, the Attorney General, in some circumstances could appoint what they said, appoint an outside special counsel to assume responsibility for the matter, right? And she wrote that into the Code of Federal Regulations. Now, the regulations clarify that outside counsel means someone from outside the United States government. Huh. Well, that's weird, because I thought we had the Appointments Clause. Weird. Now, the Reno regulations, like the independent counsel statute, they contemplate an appointment specifically. They say the word appoint, okay? Not employ, appoint. And they use as a putative inferior officer, right? That's who that person is, of a non-governmental official to an office that is fully the equivalent of a U.S. attorney. So you just get to appoint whoever? Outside lawyer? But regulations are not the kind of law that can establish a federal office, okay? These CFRs, these Code of Federal Regulations, that's not Congress. That's just the office, that's the Justice Department passing regulations that, so Congress passes the statutes, the U.S. Code, and then they create regulations about how to interpret the code, and the departments are involved in the creation of those regulations. So in other words, this is all usurping Congress. This is all being done in regulation, not by congressional statute. Only a statute can do that under the Appointments Clause, and no statute creates a special counsel with the jurisdiction and the authority that Jack Smith currently wields. Incredible. Now, the Reno regulations, they cite their authority. They say, oh, no, we can do this. Because Janet said that 5 U.S. Code 301 and 509, 510, 515 to 519 give us the right to do this. So what happens is, okay, Congress is filled with morons, as we know. So Congress passes laws that they think are great. They write all these things into the rules, and they go, this is perfect. Then the attorneys get their hands on them, and they're like, you guys are morons, okay? So then the agencies come together, and they cobble all of these together. So they'll say, okay, 509 plus 510 plus 515 plus 533. Individually, like none of those give me the authority to specifically go out and appoint a special counsel, but if I read them together, the totality of them, they give us the right to do that. And so then Reno assembles the regulations. They go into effect. Nobody challenges them until we get here for whatever reason. Now, and it might be because Durham was appointed, okay? And who are the other special counsels? Was Mueller appointed by Congress, right? All of the other ones appointed by Congress? These statutes singularly or collectively plainly provide that there is no authority for this so-called special counsel involving Jack Smith. So start with 5 U.S. Code 301, they say. This provision is a general authorization for the issuance of regulations by the AG. Here's what this says. Does this rule give them authority to appoint Jack Smith? They say the head of an executive department like Merrick Garland or a military department may prescribe regulations, okay, that the government and his department for the conduct, for the use and the preservations of its records, for the performance of its business and all of those other things, right? It gives you regulation authority. So maybe Garland can say, well, part of my regulation is to appoint a special counsel. But they say, look, this is not merely a general housekeeping provision. Nothing in it creates any offices or authorizes any creation or abolition of any offices. Indeed, if 301 were taken as a general authorization for appointment of officers, the entirety of the more numerous specific provisions for appointment of officers would be superfluous. And that's absurd. Okay, no one seriously advances it. So this is a very broad provision, but it's not broad enough to say that this section here, performance of business, like, well, I need a special counsel for performance of business. Like, no, that's not what we're talking about here. There are other sections of the law for which that applies. So then they want to go over to 509. They say, well, let's look at 509. 509 says that all functions of other officers of the DOJ and all functions of the agencies and employees of the DOJ are vested in the AG, except for some functions that they're going to say are not relevant here. But this provision also does not authorize the creation of any office. It simply says that the AG can control his subordinates. That's all. And he can personally assume and exercise their responsibilities. So it's defining the hierarchy. That's it. But it's not saying he can go out and start another hierarchy. Similarly, Section 510 says that the Attorney General may from time to time make such provisions as he considers appropriate, authorizing the performance by any other officer, employee, or agency of the DOJ. And so Jack Smith will say, oh, well, 510 says that I can just go appoint, any other officer that I want. But he says, no, that's not true here. The statute provides for a shifting authority among persons who work at the DOJ, but it says nothing about who those persons are or how they got there. So in other words, it's just it's a delegation power. Garland can delegate his responsibilities, authorizing other people to do things, but not authorizing a special counsel called Jack Smith, who's not an appointed official from outside the U.S. government, to come in and do all these things. Now, they also cite 515, and the Reno regulations cite 515 to 519. Now, again, either alone or singly, none of these provisions comes even close to authorizing the creation of the special counsel or the appointment by Attorney General Garland of a private citizen to this position. First, here's what Section 515A says. It says you're only limited to the following power, telling us that the Attorney General or any other officer of the department or any attorney specially appointed by the Attorney General under the law, which again would be statutes, when specifically directed by the AG, conduct any kind of legal proceeding, civil or criminal, including grand jury proceedings and other things, which are authorized by law to conduct, and whether or not they're a resident of the district. They say that's a pretty easy one. Thus, 515 does not, it's specifically in there, as clear as day, does not create any offices or authorize their creation. Instead, it concerns the powers of people who have already been properly appointed to offices under the law, which would be under congressional statute, pursuant to other statutory provisions, and it allows the Attorney General to designate a U.S. attorney or another special attorney also appointed under the law to prosecute a case whether or not he's a resident of the district in which the proceeding is brought. And they go on. Section 515A is thus geographical and it's jurisdictional allocative provision. It's not a grant of power to go and appoint private citizens as Jack Smiths. For example, they say in 2003, this is how this worked. This clause allowed the Attorney General in 2003 to appoint Patrick Fitzgerald, the Senate-confirmed U.S. Attorney, confirmed by the Senate, from the Northern District of Illinois to take on special counsel duties to go investigate Valerie Plame, because he was already appointed and confirmed. That arose in the D.C. Now, this is geographical flexibility. So he came from Illinois and he went over to D.C. And so that's what 515 allows. It says each attorney can then go, and go into other locations. But that is not a grant of new power. It's not something that he can hire new officers. No. He instead provides its face at attorneys who have already been hired. Okay, you've already got to have been hired because you're already appointed, and you can move them over different locations. And they may only be employees, not officers, and they can have a title and a salary. And so to be sure, they say we've got these two other provisions as well. We've got section 515A, 515B. Both of these provisions assumed that there are going to be attorneys specifically appointed by the Attorney General under the law. They say here, right? Specifically appointed under the law and specifically retained under the authority of the DOJ. But indeed, an explicit provision elsewhere, 543 below, authorizes the Attorney General to hire persons who can then be nominated and commissioned as special assistants or special attorneys. But these provisions confer no authority to create offices like the Office of the Special Counsel. The whole thing's illegal. And so likewise, these other sections, 16 and 19, they concern internal allocation of authority among existing DOJ personnel, but they also provide no authority to create offices. 519 says, for example, Merrick Garland can supervise all litigation to which they're a party, and it can direct all U.S. attorneys who are already confirmed, and assistant attorneys and special attorneys to discharge their respective duties. But there is no office creating power here either. Now, Section 519, however, it does point to the correct answer regarding the statutory authority to appoint special counsels. Section 519 notes that there are, quote, special attorneys appointed under 543 of this title. And they say, yeah, there are. You can do this. But Section 543 of Title 28 is explicit authority for the Attorney General to appoint special counsels. In other words, 543 is the thing that matters. But they're not citing that, okay? Merrick Garland and others are not citing that one. Yet neither the Reno regulations nor the Garland memo appointing Jack Smith make any mention of this provision. Why not? Because it would be bad for them. Because Section 543 does not authorize the kind of special counsel contemplated by the Reno regulations or the Garland appointment. No, it's very narrow, as one would expect from the structure of this rule. The government for decades has steadfastly refused to rely on this provision that explicitly provides them with hiring authority, and it continues to refuse to rely on it in its current litigation for obvious reasons, that the provision contains internal limitations which the government seeks to avoid. So they write in that they've got authority from a bunch of provisions that don't actually give them the authority. And what they should be referencing is this. Let's see what they're actually allowed to do. The Attorney General may appoint attorneys to assist the U.S. attorneys. Okay, so that's not Jack Smith. He's the top dog. When the public interest so requires, including the appointment of qualified tribal prosecutors, which you'll find on our Native American lands because they have their own legal systems throughout the United States, and other qualified attorneys to assist in the prosecution of federal offenses committed in Indian country. Okay, so that's not happening. I mean, maybe they would indict Trump on Indian country, on Indian land somewhere. Maybe that's another idea for him. But no, that's not what's happening here. This is in Washington, D.C., and this is in Florida. So that wouldn't apply to Jack Smith. Boy, you can see why they didn't really want to rely on that provision, because that's a big not going to happen. Now, each attorney appointed under this section is subject to removal by the AG. So This is an obvious and explicit authorization for the creation and the appointment of special assistants or special counsels who merely assist the U.S. attorneys when the public interest so requires, not bringing in some unknown person who's not even in the DOJ until he was appointed as special counsel. There are, moreover, many contexts in which the appointment of these people makes sense. The government often encounters problems for which private lawyers have expertise, right? A U.S. attorney might not be an expert on, technical aspects of spying, for example, although they're probably pretty good at it now since they've been doing it for years. But they might want to bring in another attorney to help them on a case. But he's not taking over the case. He's still working under and subordinate to the Senate-confirmed U.S. attorney and their office. So either gain from past or government service that might be useful, crime, banking, antitrust, tribal law, and so on. All that makes sense. Those lawyers may not want a permanent government position, but may be willing to help the government on a limited basis, perhaps like on a task force or a team dealing with specific knowledge. But an appointment as a special assistant or a special counsel under the control of a U.S. attorney is an obvious win-win in many such cases, but not here. Now, the problem for the government in this case, and in the case of the Reno regulations and the Smith appointment, is that those regulations and the Smith appointment and or do not contemplate special counsels who assist U.S. attorneys. In other words, they're in violation of the section. Instead, they contemplate special counsels who literally replace the U.S. attorneys in specific cases. Smith, for example, was not appointed to assist U.S. attorneys. He was hired as a powerful standalone officer who replaces rather than assists the functions of other U.S. attorneys within the scope of his jurisdiction. This is precisely the role that the Ethics in Government Act authorized for independent counsels. That's why we have that. We don't anymore, but we did. But that statute no longer exists, and so they can't do that. And in the absence of that statute or a similar one, there is simply no statutory authority for the office of the special counsel. It is illegal. And Smith could be appointed, to which Smith could be appointed as a stand-in for a U.S. attorney, was not confirmed by the Senate, is not a U.S. attorney. And so the remainder of Title 28 confirms this conclusion. Just read the law. Section 533, which is relied upon by Attorney General Garland, is part of a chapter dealing with the FBI. Okay, so he dug that one out. I have authority under 533, but that is about the FBI, not the DOJ. It's about investigative and other officials. Here's what that section says. It says the Attorney General may appoint, quote, officials to detect and prosecute crimes against the United States. They put officials there. To assist in the protection of the president, to assist in the protection of the AG, and to conduct other investigations regarding official matters under the control of the DOJ and the Department of State as directed by the Attorney General. So he can appoint officials, right? But 533(1) is not a general authorization to appoint officers. It specifically and solely authorizes the appointment of investigative and other officials. Officials, not officers, sounds pretty close, connected with the FBI. This does not include special counsels. It's FBI provision. This is clear for three reasons. One, when you look at the law, 533, when you look at where it is in the law, it's in Chapter 33, and that deals with the FBI. Section 532, immediately before that, is entitled the Director of the FBI, and it spells out the Attorney General's authority over the FBI. Then 534 concerns preserving evidence in criminal cases. So just look at it in context. Okay, it's FBI here on 532, 533, FBI, and then 534, FBI. But Merrick Garland is saying, wait, I'm going to use that for my office. So thus, 533 clearly deals with FBI officials and agents, not special counsels. And it makes sense in the context of this, right? Investigate and prosecute crimes, but also protect the president, protect the AG, and so on. So here they say, this is how the government has long understood this provision, which has been employed as the basis for the FBI's law enforcement authority. And second, 533 concerns the appointment of investigative and prosecutorial officials, not officers. Such officials, and that term as it's used in the statute, are not Article 2 officers of the United States, and they cannot perform the functions of officers of the United States. They are non-officer employees who, as FBI agents, must be subject to the supervision and the direction of officers of the United States. So, the FBI, it needs office and field personnel to perform its functions, and that's why 533 allows the agency to have those officials. But those office and field personnel are not officers of the United States, and they do not have the range and the power of a special counsel. But to the contrary, they say, the word officer is a constitutional term of art, not only because it is used that way in the Appointments Clause, which governs this, but also because Article 2, Section 4 of the Constitution allows for the impeachment and the removal from office of all civil officers of the United States. We need a removal mechanism. Congress can try to impeach the Deputy Attorney General or the FBI Director, but no one thinks Congress can impeach the DOJ trial attorneys. No one thinks that the Office of Legal Counsel Attorney Advisors or field personnel at the FBI can be impeached. It's officers. Now, what is more, officers can be put by Congress in the line of succession to the presidency. They serve a role in our constitutional order. We look at the Constitution for that. But no one thinks that investigative officials at the FBI or DOJ trial attorneys who are bureaucrats, tell me about it, and employees can be put in line of succession to the presidency. That simply is not how the Constitution was using the term officials in Section 533. Now, they say an 18th century statute might have used a term like officials to have broader meaning than here. Even Judge Thomas is saying that. But as a matter of statutory interpretation, however, there is no plausible case for reading the term as it appears in 533 to be coextensive with the constitutional meaning of the term officer. You know, officer in America is very different than just a regular official. And they say third, and perhaps most tellingly, a cavalier reading of Section 533 to authorize hiring beyond its obvious FBI scope, it obliterates the structure of all of the title. That title is divided into chapters dealing with the Attorney General, the FBI, U.S. attorneys, marshals, U.S. trustees, ATF, and others, and the now sunsetted Independent Counsel, which is now dead. Wide-ranging special counsels of the sort represented by Smith are not part of these provisions outside of the now defunct Ethics in Government Act sections. Continuing, saying at a more granular level, the effect of a loose reading of these statutes is even more bizarre. Congress, as noted earlier, has provided for the appointment, all with presidential nomination and senatorial consent, of an AG, an associate AG, solicitor general, 11 assistant AGs, and so on. And exactly one U.S. attorney for each judicial district, currently 94. Got to appoint each one of them. Now, a reading of 533 to essentially create unlimited inferior officer appointment power wreaks havoc on this structure. Okay, in other words, if Merrick Garland can just avoid all of that, I actually don't even need the Senate. I can just appoint my inferior officers however I want. It would allow the Attorney General to appoint an entire shadow DOJ to replace the functions of every single statutorily specified officer. No wonder the Reno regulations did not invoke it. Okay, no wonder, in other words, they didn't even look at this because they knew that if they put it under that power, it would clearly be attacked. So the DOJ is, you know, as gross as you could ever imagine, right? They probably know this and have been squeezing this through until finally we see that it is illegal. Now, for the reasons described in depth in this court and in the case in Nixon, Nixon did not pass on the scope of the law. The decision contains some ill-considered dictum regarding 533, meaning it's not relevant to the actual holding, but it's bad dictum and it merits no weight. Anyone tempted to rely on Nixon as some sort of an endorsement of 533 should read the case briefs to see what the issues were truly raised there. Those issues involved only the relationship between the president and the DOJ as an institution. The same arguments would have been raised if the Attorney General personally, rather than the independent counsel, had brought the suit at issue there, but that didn't happen. Nixon was argued and decided before the modern rebirth of separation of powers, which dates back to 1976. So they say don't think of Nixon as something that essentially codifies this. In short, writes Mr. Edwin Meese, the position supposedly held by Smith, special counsel, illegal, was not established by law. The authority exercised by him as a so-called special counsel far exceeds the power exercisable by a mere employee, Jack. He is acting as an officer of America, but aside from the fact and the specific offenses, aside from the specific offices listed in the statutes discussed above, there is no office that he can validly hold. That alone robs him of his authority to represent the United States in any capacity, including before this court. Telling us the Appointments Clause establishes a default rule. All heads of department and their principal officers are subject to Senate confirmation. Even if one somehow thinks that existing statutes authorize the appointment of some standalone special counsel with the full power of a U.S. attorney, Smith was not properly appointed to such an office. No statute clearly authorized his appointment by any mode other than presidential appointment and Senate confirmation. Any such statute, of course, is governed by the Appointments Clause. Look to Article 2, Section 2 of the Constitution. That tells us that the president shall appoint ambassadors, other public ministers, counsels, judges of the Supreme Court, and all other officers of the United States, whose appointments are not here enlisted, but which shall be established by law, by statute. But Congress may, by law, vest the appointment of other such inferior officers as they think proper in the president alone, in the courts of law, or in the heads of the department. Okay, that's the Appointments Clause. Now, this sentence makes three things clear. First, the default mode of appointment for all officers, which they claim Jack Smith is, whether superior or inferior, is presidential nomination, Senate confirmation, and then presidential appointment. With Jack, did not happen. Second, this default presumption can only be overridden by Congress in the case of inferior officers. And third, which didn't happen here, and third, even in the case of inferior officers, Congress must speak clearly to authorize the permissible mode of appointment for those officers other than presidential nomination, Senate confirmation, and the presidential appointment. And so this latter clear statement rule is implicit in the Appointments Clause and the constitutional structure. That clause is both a separation of powers and a federalism provision. It divides appointment between the president and the Senate. That's done with good reason. Not between the president and Congress as a whole, which lacks power to appoint and confirm appointees. The Senate is the body in which states receive equal representation. We all get two, whatever their size or population, which guards against large state presidents underrepresenting smaller states in the executive and the judicial departments. As one convention participant put it when they were writing this stuff, presidential power without the check of the Senate would allow presidents to gain over the larger states by gratifying them with the preference of their citizens. And so these structural concerns warrant an interpretive presumption in favor that we need clear statements from Congress if they're going to allow other inferior officers to be appointed. Now, even if you don't find this presumption, simple ordinary statutory interpretation demonstrates that the Attorney General received no power to appoint special counsels as inferior officers. None of the statutes canvassed in this motion, in this brief, show any authorization. In fact, the opposite. In contrast, the DOJ's organic statute, the organic statutes of agriculture, education, health, and other things, they do contain inferior appointment. Look at this. If you look at other domains, let's step outside from the DOJ. Let's walk next door to agriculture. Let's go see what's up at education. Let's see what's happening with Health and Human Services and the CDC. Let's say what's up with transportation and Pete Buttigieg on paternity leave. All of those other agencies, they do contain inferior officer appointment power clauses. Congress put them in. Thus, the Agricultural Secretary, according to their rules, may appoint such officers and employees, according to Congress. Education is authorized to appoint such officers and employees. Health and Human Services is, quote, authorized to appoint officers and employees under 42 U.S. Code. 49 U.S. Code. Transportation, they can appoint officers. And Congress gave the AG the power to appoint additional officers and employees as he deems necessary, but only specifically for the Bureau of Prisons. Okay, so if you go over to 4041 of Title 18, he can appoint officers, but only for the Bureau of Prisons. Okay, limited, not for the DOJ. No, it's unclear, they say, why Congress chose to give general inferior officer appointment power to the other secretaries, but not to the AG. Don't know why they did that. It may be because of the unique threat that an unwise attorney general could pose to civil liberties, like if they prosecute their political opponents. They might be able to wreck the separation of powers. They may be able to wreck federalism. But this court does not need to divine Congress's reasons for making different policy choices because the relevant statutes are unambiguous. Don't need to read their minds because you just need to read the law. Now, even if Jack Smith was statutorily authorized, they would be a superior officers who would need presidential appointment and Senate confirmation. So saying, look, Supreme Court, if you find that the statutes do grant him some right to be here, if he actually had the power to convene grand juries and issue subpoenas and direct and conduct prosecutions and file appeals, if he could do all of those things, then he would obviously be an officer of the United States. Okay, he would not be a mere employee if he could do that. But more than that, he would be a superior officer, okay, or a principal officer, because that's what these people are. It says, and by plain terms of the Appointments Clause, superior officers must be appointed by the president and they must have the advice and consent of the Senate. That is not how Jack Smith was appointed. And he thus could not serve as special counsel, even if such a position validly existed. So, two things here. Okay, one, he's saying the special counsel's office is invalid, right? There is no other office for Jack Smith to be in. Even if you find the office is valid, Jack Smith as a man is not allowed because he was not appropriately appointed. So it's a blowout in both arguments. Now, the special counsels contemplated by the Reno regulations are the equivalent of, if not more powerful than U.S. attorneys. It is obvious that as an original matter, that U.S. attorneys are superior offices. And the same is true of special counsels who mirror them. And so the only plausible argument to the contrary rests not on the original meaning, but of some other court decisions that were wildly overread. Those decisions contain language that you may be able to extract, but federal courts should hold against them, because could Congress therefore let the Attorney General appoint the Court of the Appeals judges? Could Congress in other words, could delegate all their appointment power to the AG? No, of course not. That doesn't make any sense. So saying one can be a superior rather than an inferior officer in two ways. One is to have no decisional superior other than the president, which is kind of what Jack has. The other is to have so much power and authority that one is superior in a substantive sense. And both of those Jack Smith is. Now, as Justice Souter perceptively wrote in another case, he says the terms are confusing, but in this case, either way, if Smith is an officer, he is a superior officer. He has no supervising person. No one's directing him. Attorney General Garland does not supervise or direct him, so he says. And as he said, he would not when Smith was appointed special counsel. And so, sounds like he's superior, according to even Merrick Garland's own conclusion. And so Smith has without the participation of the Solicitor General, filed a petition to this Supreme Court on behalf of the United States. He can't do that. Only the Solicitor General can. He's prosecuting a former president, the first time that that's happened in our nation's history. Smith is purporting to exercise at least as much power as a U.S. attorney and arguably more. This is the hallmark of a superior officer who must be appointed as such. And so the absence of such an appointment means that Smith lacks the authority to even entertain certiorari at the Supreme Court. And that is a powerful, sufficient reason to deny his petition. Saying in conclusion, Supreme Court, not clothed in the authority of the federal government, Smith is a modern example of a naked emperor. Improperly appointed, he has no more authority to represent the United States in this court than Bryce Harper, Taylor Swift, or Jeff Bezos. That fact is sufficient to sink Smith's petition, and the court should deny review. We express no views on the merits issues addressed in Smith's unauthorized petition. Respectfully submitted by Gene C. Scher, Justin Miller, Aaron C. Ward. Outstanding brief as counsel for the amici curiae, who are, as we know, Edwin Meese, former Reagan AG, law professor Stephen Calabresi, and Gary S. Lawson, doing amazingly incredible legal work here, exposing and spotlighting for all of us to see that Jack Smith is an illegally appointed so-called special counsel, not even properly vetted, appointed by Joe Biden, confirmed by the Senate, not a U.S. attorney, completely outside of the law. Illegitimate, the whole thing. And this is exactly what we would expect from these people, because they did the same thing with the January 6th Select Committee. Remember, they passed H.R. 503, said we create this committee, and they illegally constituted that. It was made up of the wrong people, and they conducted it anyways. So all of this is now being exposed, and I am very hopeful that the Supreme Court will take this to heart and invalidate this entire area of law, because that is one way to handle this whole thing. They don't need to make immunity decisions. They don't need to get into double jeopardy. Jack Smith is just done by virtue of statutory operations. Was he legally constituted? Sorry, Merrick Garland. And the whole thing could go away right then and there. Now, I think there are other very important issues the Supreme Court does need to address. I do want to hear about double jeopardy. I do want to hear about the insurrection clause, the 14th Amendment, and all of these other things. But this is fascinating, okay? From a technical perspective, Merrick Garland and the DOJ, they have been tap dancing on the head of a pin, man. They are just about to fall off on this thing everywhere you turn. He's not even legitimate. And this is an outstanding brief. Now, this is what we're going to hear in reaction to what is happening against Trump. This person is a Republican election lawyer, and he was on CNN, and they had this exchange where they're talking about what's happening, okay? Colorado is booting Trump off the ballot. We've got 4 different criminal indictments. Jack Smith is illegitimate. We've got all sorts of issues popping up at the Supreme Court. And now CNN and Jen Psaki are freaked, man. They're like, what are we going to do about this if Jack Smith's not even legitimate? I mean, they're doing cartwheels around this guy. They're like a hagiography for Jack Smith. They love him because he is taking out their enemy. But the dude is not even legitimate. Here is some conversation about the status of Trump's cases, and listen to what happens when Caitlin Collins hears some of this news that the court is probably going to find in Trump's favor.
Wait to see what the Supreme Court's going to have to say about this. What if they don't?
Let's boost this volume up here and see if we can get it a little bit louder and elevate the sound here.
Have anything to say about it for a while?
I don't think we've ever been in a moment in history quite like this before, in that we have 3 enormous cases pending or potentially pending in front of the Supreme Court, each of which will drastically impact the election. We have this one, first of all,
which we know, that's the whole
will,
point.
I think, obviously determine whether Donald Trump's on the ballot in Colorado and potentially elsewhere. We are waiting on whether they will rule that Donald Trump is immune in his federal election challenge. And if he is, that case goes away. We're waiting to see if they take that. And at the same time, the Supreme Court has taken a case which will essentially determine whether two of Jack Smith's four charges, the two obstruction charges, will stand against him. So all three of these cases either are in front of the Supreme Court or likely will soon be. They all will determine either directly whether he's on the ballot in certain states or indirectly whether he takes a major hit to his electoral fortunes.
I mean, Ben, that's pretty remarkable what Ellie just laid out there. If you think about everything that is going to be before the Supreme Court, that could
lawfare
determine
onslaught.
Donald Trump's fate, so whether it's electorally or criminally.
Yeah.
Yes, and plus the country is much more divided now than it's ever been before. I mean, in a sense, if you're a Supreme Court justice, it makes Bush versus Gore look like a walk in the park. And of course, three of the Supreme Court justices were down in Florida litigating Bush versus Gore. But this is a moment where the Supreme Court, no matter what they do or if they don't do, is going to play a major role in the presidential campaign, which puts a real premium on them sticking with legal principles about when they do have to weigh into these.
Well, Ben, then what did you make of Sean Grimsley, the attorney who was arguing in front of the Colorado Supreme Court, which has a very different makeup than the U.S. Supreme Court? He says that he doesn't think that that has anything to do with even politics, for some critics of the Supreme Court who will think that. He thinks that they will prevail here. I mean, do you believe that that's likely at all?
No, actually, I don't. I mean, I think the only people who have found that Donald Trump committed insurrection have been his political opponents.
Bingo!
And I think that's pretty dangerous for the country and not a real incentive for the U.S. Supreme Court to rule that way as well. I mean, the deference of Supreme Court cases has always been to let the voters decide.
Right.
And so making rulings knocking somebody off is not what they've ever done before. Granted that an insurrection charge and everything that's gone on with Donald Trump is, as Ellie's pointed out, really unique in our history.
Yeah, it's going to be, I think, a difficult thing to have the Supreme Court disenfranchise 1.3 million Coloradans. I'm not sure that they're going to do that. Despite what they might want to have happen, the likelihood that that happens, I think, is low. But maybe they just toss all the cases out based on presidential immunity. They could have double jeopardy for the J6 stuff. That would invalidate the Georgia case. That would invalidate the DC case. We would still have, if presidential immunity comes back, we would have, I think, exonerations. Well, maybe Florida would still move forward, but they are nervous about this. They're not liking the answers. Trump keeps going up in the polls, and they're freaked. Here on MSNBC's new hit show called Inside Jen Psaki, these two guys are having a conversation with her, and Jen is asking them, what can we do? Can we indict him again? Is there anything? A lot of Trump supporters are not going to leave his side, and we're starting to lose, and we're freaked.
As you wrote in your piece, as we can see in the polls and examples I just cited, durable coalition. There's a durable coalition that seems to be kind of rolling with Trump and what he's saying, what all of this racist rhetoric, this language that many people say, this is not who we are, which you talk about in your piece. What can Democrats actually do about that?
Well, first of all, they can accept it, that the durability of this is going to continue. I mean,
That's
there's a body of forgiveness.
We're not going anywhere.
Celebration of this kind of rhetoric that now goes back 7 to 8 years. So, I mean, that is here for good. What I think was interesting about the intro that you just did was the quote from, I guess, the woman in Iowa. People call me a dictator. I mean, there is a glibness to this, but there is also a celebration of strength. And I think it was your former colleague Dan Pfeiffer who said in his message, he has a really good message Substack thing, but he basically said, look, when he says dictator, uses words like that, his supporters do like it. I mean,
they like that, that he's strong.
It is strong.
Yeah, that's right, we do.
He has primed.
Yeah, we like that he's going to balance the scales of justice. Okay, you guys have perverted it by becoming little dictatorial maniacs who are prosecuting him in many locations. And so when he says that we're going to even the scales, we're going to return this to norm, yeah, you better believe we like that, because we want justice, and we don't want weaponized political prosecutions by hack prosecutors across America. And so if there are people who are involved in malicious prosecutions, if there's a bunch of people who created a conspiracy to get a U.S. citizen indicted because they don't want to run against him, okay, that's not justice. That's not due process of law. So yeah, we are excited about him coming back and returning to form.
And these supporters over a long time. He's definitely dialed up the rhetoric, but he also contrasts it with what he perceives Joe Biden to be and what voters have perceived Joe Biden to be next to this dictator, a weaker leader, someone who is older, someone who is more reserved. So it's actually getting a lot done for him. And yes, we can sort of roll our eyes or actually get really alarmed at this at our peril. But ultimately, this is actually, there seems to be a method to this.
There is a method to it, yeah, because we're watching him respond to your corruption, okay? It's not just like Trump is just waking up like, I'm just going to cause havoc in the country and just go after my enemies. No, it's you guys have perverted the entire sense of justice in America, and we're excited about a return to form. And so Jack Smith, as we know, illegally appointed, not even validly constitutionally allowed to be bringing these prosecutions. And Edwin Meese and those law professors are outstanding heroes for calling this to our attention. And we'll see what the Supreme Court says about this, my friends. Now, we're going to be continuing to cover this one at length. And so I hope you join us at robertgovea.com if you want to get the red lines on the document and review the full PDF. It is over there, robertgovea.com. We have a nice new shop up there where you can grab a new hat that includes the Watcher logo on it. And the Watcher logo is Justitia, it's Libertas, the Roman goddesses combined into one. It's got the scales of justice. It's got the shield and the sword to cut through the bonds of ignorance. And I wear this every day to the gym, and it's getting even a little bit dirty here. But we are going to continue to cover this, my friends. So thank you for subscribing, and we'll look forward to seeing you on the next one. All right. And so we've got one final segment to attend to here, and we're going to jump over to what's happening in Florida and see what's going on there with these classified documents case. Donald Trump objects to Jack Smith's jury questionnaire. We know that trial is not scheduled for quite some time in Florida, and it might move, but Jack Smith wants to pick up the pace like right now. He wants the jury questionnaire to be assembled and go out, and Trump is saying, what? I haven't even reviewed all the discovery yet, so how would I even know what to put on the jury questionnaire? So Jack Smith is asking Judge Cannon for permission to do this. Trump is responding saying, how dare you? And he's actually asking Judge Cannon to tell them to knock this crap off, saying they are trying to mess with this litigation by jumping ahead in the schedule. Judge, you've already issued a schedule on this, so let's just stick to that one. So the objection comes, and we're going to take some reaction from Nikki Haley and from Bill Barr, because Nikki Haley's just ignoring all of this, because if Trump gets removed, maybe she slots in the number one position. But this is what Jack Smith is referring to when he submitted his motion. Jack Smith wants a jury questionnaire in the Florida case. This is the government's motion in the case of United States of America versus these three co-defendants, obviously Donald Trump at the top of the list, along with the other two. This is the classified documents case. And this is Jack Smith in a short filing asking for a written questionnaire to be completed in this case. They say, you know, the pretrial publicity in this case is pretty substantial, and the government wants a very thorough jury selection process, including a written questionnaire and so on. They say, you know, this is pretty common now, and it's going to make jury selection far more efficient as this moves through. Saying the government is mindful here that the court issued a prior order saying that apart from the date set forth and the date set forth for the calendar call and the trial, that any further deadlines will be set in March. So Judge Cannon told him, hey, shush for a little while, okay? I already scheduled the calendar. Don't put any more stuff on my calendar. But Jack Smith says, but we really want to go fast, Judge. However, given the lead time that the clerk's office will need to implement a jury questionnaire, beginning the process after March 1 will not give the court enough time, and we have to get Trump convicted like now. So as described below, previous cases in this district, we used questionnaires, and it took them 10 weeks to do this. And so we have to mail questionnaires to jurors, and then that has to be postmarked, and then that means a final questionnaire would need to be approved by March 11th for a May 20th trial date. And so they really want that trial date to stand. And we're also asking ourselves, that's probably going to move too. Now, as an alternative, the court could have the jurors summoned to the courthouse in advance. So if you don't want us to mail this stuff out, bring the jurors to the court and let them in here. And so for these reasons, the government moves the court for a new deadline, add something to the calendar on February 2nd. Now, Trump is going to respond to this. He's not happy about it. The government has conferred with the defense counsel, and they oppose the motion because they think this is premature and this is not a good use of time. But the government disagrees. And so they say here, a jury questionnaire is going to protect the defendant's rights. This is for Trump. We're doing this for Trump. We're going to make sure we have a fair questionnaire and a fair jury. In Sarnov, which was, I think, the Boston bombing guy, they used a 100-question juror form. In Skilling, an Enron executive, they used a 14-page questionnaire, and courts in other districts have used these as well. We can finalize these well in advance of trial, and for these reasons, Judge, we want you to do this. Let us use a jury questionnaire, and let's get this started now, because we got trial like in May, and we want to get it finalized. So the parties submit here. They say, please set a new deadline, and then let us know where we can submit our questionnaire. Signed by J. Bratt, counselor to the illegally constituted Special Counsel's office, which is not even legitimate as an office under American law. So this was all submitted and sent in to the court. Now, Donald Trump responded to this, and he's not happy about it. He says, all right, look, we've got stuff on appeal. We're claiming presidential immunity. There's classified materials that we haven't even seen yet. We're tired of this. They say, guess what, Judge Cannon? President Trump respectfully submits this response, saying that Jack Smith wants to set a deadline. Well, frankly, the court should deny this most recent effort to set new deadlines outside of your schedule. And in addition to this, Judge Cannon, wasting the court's resources, this type of litigation also detracts from Trump's efforts to review all of the discovery and all of the other motions that are crucial to our defense. So stop interrupting us when we're preparing our defense. Therefore, President Trump respectfully asks that Judge Cannon order Jack Smith's illegitimate prosecution to refrain from further motion practice outside the existing schedule unless there are actually compelling circumstances, not just they want to race this case to trial. Saying, to be clear, in the event that the court does not dismiss this politically motivated election interference mission by the Special Counsel's office and the Biden administration, and the defendants, if you don't just voluntarily dismiss it on your own, Judge, we are going to submit multiple compelling bases for doing so, and we're going to do that in our motions, which are due in February 22nd. Now, if you don't dismiss it, then President Trump does not dispute that a questionnaire may in fact be appropriate. Like, we might be okay with this. In connection with the trial where defendants will exonerate themselves. I love this bravado, man. I love it. Yeah, we could use a jury selection to have a trial where we will be acquitted. Happy to do that. But that is not manifestly what this motion is about. Apparently, Jack Smith believes that this case is governed by baseball rules. The office has taken another swing at maintaining the trial date that was set based on this office's, Jack Smith's, original misrepresentations regarding the timing and the nature of discovery. The court rejected their first attempt to do this. You remember, Judge. You said that deadlines and all other pretrial deadlines will start later. And in this motion, they claimed, based on, quote, experience and research, and that they ignored the court's prior use of the phrase, Jack Smith's office arrogantly purports to educate the court, Cannon. He's telling you about your logistics of jury selection in your honor's own district as a pretext towards rushing towards an unjust trial. This motion is every bit as much as a whiff, and therefore strike two. The prosecution's purported concern about insufficient time to implement jury selection is illusory. It's based exclusively on partisan talismanic significance that they have assigned to May 20th. It's this anchor. There's no criminal reason for it, but they got to get it done before trial. If there could be any doubt about the true motivation behind the motion, it's obvious, though largely omitted from the motion, that such a questionnaire would need to give potential jurors a sense about when the trial would occur, and the court has already made that clear in March, saying any jury questionnaire would also have to estimate the length of the time of the trial. One necessary component of the estimate of the length of the case is going to be, the defense's case, because they're going to have to put on their evidence. And the length of the defense's case is going to rely on part about what discoverable material that they can get. So Jack Smith is going to have to give them information so that they know what their defense is, so that they can prepare the jurors for it, saying that it is necessary for the cross-examine of prosecution witnesses, and the court has noted the same. So the pretrial rulings will also be critical to additional key features of any jury questionnaires as well. We need a summary of the case. We need questions about improper biases. As we're still preparing our defense, we're reviewing all of the voluminous discovery. We've noted that there is important as of yet unproduced materials that we need, and Trump's pretrial motions are going to attack those aspects. For example, they say Trump's defense is going to bring to light important issues regarding the timing of Trump's security clearances, the timings of the FBI's illegal raid at Mar-a-Lago, the unlawful disregard of Trump's attorney-client privilege, other grand jury abuses, not to mention prosecutorial misconduct. Oh, yes. Selective prosecution, witness advocate problems, improper and unconstitutional involvement by the Biden administration and the National Archives, related abuses of the Presidential Records Act, the lack of sensitivity of certain documents, and flagrant overclassification of other materials. Now, that is to say nothing of the extensive SIPA litigation that is also going to be necessary, the time consuming before a fair trial can be conducted if one is necessary. If any of the pending charges survive these and other motions, and they should not, it will be incumbent upon you, Judge Cannon, and the remaining parties to administer jury selection procedures that are attentive to these particulars of this case. Any, quote, joint questionnaire proposed by February 2nd would not allow for us to do this inappropriately. So we would just be making up questions. Therefore, it would be a waste of time. Now, because the special counsel's office is demonstrably not committed to a just outcome in these proceedings, the office views the amount of work to be accomplished by the court and the defendants in litigating and resolving this, at most, a minor speed bump on the office's desired path of using Your Honor's courtroom for political advocacy. They are using your courtroom, Judge, to attack the leading candidate of the 2024 presidential election in a key state and beyond. And judges don't like when their courts are used as levers. And this happens not only in political cases, like if you try to go, if you're in the middle of a custody proceeding and you file a domestic violence claim against your spouse. It's like, okay, we know what you're doing here, and screw you. The prosecution has unapologetically misled the court from the start. For the second time in just over a month, Jack Smith have ignored the court's scheduling order in an effort to impose deadlines with no reasonable basis. And so Trump respectfully submits that this court should put an end to these improper filings and admonish Jack Smith, who's illegitimate, that future abuses that interrupt the defendant's discovery, review, and defense preparation will not be tolerated. And so for the foregoing reasons, President Trump respectfully submits that this court should deny the motion to set a deadline and submit jury questionnaires, and tell Jack Smith and his office that any further motion practice outside of this existing schedule, absent truly compelling circumstances, should not be done. And please refrain from bothering us while we're working. Sincerely, Todd Blanche and Christopher Keese, Trump's defense team. And so, this is more fun stuff. We expect Cannon to probably adhere to the schedule. Sorry, Jack. You're not on schedule. Get back on track. And of course, that case will continue to move forward as well. Now, some people are ignoring all of this, right? Nikki Haley is one of them. And she was out there almost giddy and gleeful that this stuff is happening, promising that as part of her run for presidency, she does not want to hear about any of this stuff. Trump stuff is outside the purview, and she's focusing on her and her alone. Forget the fact that the DOJ has been weaponized. Forget the fact that Trump has been indicted and they're trying to remove a candidate from the ballots in various states. Doesn't care about any of that. Just wants to stay focused on winning.
Governor, nobody's going to vote for Nikki Haley because you said to vote for her. Maybe some people, but not a lot. But
that's nice.
What kind of question is that? In the midterms, a number of candidates you endorsed lost to much more Trump-centered candidates. I'm old enough to remember when your father endorsed George W. Bush in 2000, and McCain ended up winning by 18 points. So why is this going to be different?
We have 40 days. We're going to be out on the trail. We're going to be helping that grassroots support, helping build folks up. But right now, there's so many folks undecided. Everything's been delayed. A lot of the decisions won't be made really until the last couple of weeks. And in New Hampshire, it's all about results. So if you're results driven, you want that efficiency in government, here's the path. Not just to get the Republican Party unified again, but the entire country. Give them a strong next generation of conservative leadership that everybody can get behind.
All right, come on.
And what I appreciate about Chris's endorsement, it's not a one and done. This, for the next 40 days, we're partners because we honestly believe we have a country to save, and we're determined to do it.
So let me ask you, speaking of Trump, he has claimed absolute immunity in his defense to the election interference case. Is that your view? Do you believe a president has absolute immunity for anything that happens while they're president?
I'm going to let the courts figure that out. I mean, the last thing you're going to see me do is weigh in or learn the details about any of his court cases because I can't follow 91 charges, and I'm not going to.
That makes total sense, but let me just ask you
Not really.
principle. Forget his case.
Not really. So, Nikki, you're cool with the Democrats taking out right-sided candidates so that you can have a clear path to the nomination? Like, you're not concerned about the weaponization of our government against the political process? You're okay with 1.3 million Coloradans being thrown out of the political process because you can't keep track of it? Are you nuts?
Do you think that a president of the United States, that if you get elected president, you would have absolute immunity for anything you did while you were president?
That's not the standard, idiot. The standard is for official acts, which is what Trump was doing. It's not anything, okay? You can't go out and just start eliminating people.
I think the court issues are, do you have immunity when you're president? When you're not president, at what point does that line fall? I'm going to let judges decide that. I don't know where the line falls. President Trump's going to have to defend himself, no matter what. If he's found guilty, he's found guilty. If he's found innocent, he's found innocent. It would be wasted energy for me to sit there and focus on court cases and not focus on how to win that room that we just left.
Wild. So doesn't care, whatever. And if Trump does get convicted, if Trump does get thrown off the ballot, she'll be much happier about that because she'll be able to squeak into victory, right? These people are just disgusting. Like, why would you want to win by having your top opponent taken off the ballot? It's because you can't win on your own, and that is weak and pathetic. Now, even this guy, Bill Barr, who is not a Trump fan, is recognizing that this stuff is problematic, saying Colorado's not a good one. Here's Bill Barr.
The core problem here is the denial of due process. To deprive somebody of the right to hold public office requires due process. It requires an adjudication of two core issues. One, was there an insurrection? Did the public disturbance rise to the level of an insurrection? And second, what was the role of the individual in there? Was it engagement? Did they do something to break their oath of office? Those are complicated facts, and this was denied due process. It was a 5-day hearing. There was no jury. It was before the judge. They were not able to subpoena witnesses and compel the attendance of witnesses. They relied on the hearings, the January 6th committee hearings, which is mostly hearsay. There was no right to cross-examine during those hearings and so forth. So as the dissent said, and by the way, the three Democratic justices who dissented, their opinions, I think, are masterful. And as they pointed out, they said, the process here was a procedural Frankenstein.
Yeah. They had one mission, which was to get rid of Trump. And you know what? It worked out. And the people who are formulating these plans, they are not done yet, my friends. Now, they are going to continue to try this stuff. They are freaked out, but we are seeing some very good progress being made in the courts. We're knocking at the door at the Supreme Court. We've got Trump's team looking like they're firing on all cylinders, objecting to different jury questionnaires, submitting briefs to the Supreme Court. And now we have an idea that Jack Smith might be illegitimate in the beginning. So we are going to be covering all of this and more, my friends. There is a lot of Trump trials to follow out there. And so hopefully you're inviting a friend or family member to come and join you and join us when we cover this stuff here. We'd love it if you subscribe to our channel. We'd love it if you went over to robertgovea.com and got a brand new Watcher hat. And we'll look forward to seeing you on the next one. All right, my friends. Well, we covered some good ground today. Donald Trump is objecting to Jack Smith's jury questionnaire. We've got Jack Smith's illegal appointment, and that was a ton of fun. So please share this one, okay? We're going to get that recorded as a segment. So come back and share that one. I want everyone to see that one. And then, of course, Donald Trump is also knocking at the door of the Supreme Court, telling them, hang tight. We don't need to be in front of your courtroom right now. And so now, my friends, it is time to hear from you. We are going to go over to our members only after party called at watchingthewatchers.locals.com for an after party. And so come and check us out over there. But before we run over there, let's say hello to you. Thank you for your incredibly generous support today. And it is a beautiful day. We've got Brian Yeager, first in the house as a supporter. Welcome aboard. Barry Y in the house as a supporter. Aaron K is coming in as a supporter. What's up, Aaron? Thanks for being a supporter, man. 2 new membos coming in the house. Brian Declan on local says, keep doing good. Thanks, Brian. I'm going to do it. You keep doing good, my man. Be good. We got Pinecone gifted 1 membo. Eric with a K is coming in, courtesy of Pinecone. Thank you for that one, Pinecone. Hey, Luke's Television Review is on here. What's up, Luke's Television Review? Says, okay, since the U.S. Supreme Court presided over the Senate's J6 insurrection trial, the U.S. Supreme Court has already essentially ruled that President Trump is not guilty of any insurrection. And I agree with that. Yeah, and it's going to be curious to see if they say that everything that they did was also irrelevant. Like all of that was like mostly meaningless, and any other just, kangaroo court like Colorado can just decide differently, even though the Supreme Court was there and in attendance. We got Tony Hay Munkets. What's up? Bringing in new membos. Tony Hay bringing in Harlan R, Laura, Dyer Gnome, David M, Harlan R again. We got Laura, Dyer, and Jay Liebgott, Jerry C, and Mother of P, all coming in courtesy of Tony Hay Munkets. Tony, thank you for that, man. Very, very nice of you. Oh my goodness, look at this nice one. Says a nice one from To Be a Girl 74. Says, thank you for everything you do to educate us, Rob. We'll be in your area nearby for the Fiesta Bowl. I'm from Northern Virginia and looking forward to exploring the area. Amazing. Okay, so it's going to be a great time here. The weather's going to be beautiful. And how fun is that to be a girl? You know, we need to kind of come up with a meetup plan or something like that for where we can all get together. But Arizona is going to be beautiful to be a girl, and I hope you have a very safe trip. Thanks for being so generous with this lovely dono today, and enjoy the Fiesta Bowl. It's going to be fun. Tony Hay, bringing in CG, Tornado Sunflower, Gail G, Julius V, and Stephen F coming in courtesy of Tony Hay Munkets. Tony, thank you very much, and welcome aboard, my friends. Zulu, says, nearly finished with Giuliani's biography. The first 90% of it is a twisted freak show, but chapter 11, makes it all worthwhile. Highly recommend for the laughs. But all right. So that's a good one, Zulu. That's a good one, Zulu. And yeah, man, I think that's pretty funny. So it's not funny what's happening to Giuliani. It's a travesty, but that's a pretty funny comment. I have to admit that. So because Giuliani filed Chapter 11 bankruptcy because he's been under attack by lawfare for making comments. So thank you, Zulu. We've got Catherine Rex bringing in Thomas R, Jim F, Lao Su from, I think that's from Mortal Kombat, Captain Flatastic, and Brian Evans, all courtesy of Catherine Rex. Catherine, thanks for doing that. I did get your email, and hopefully you enjoyed the segment on the Jack Smith stuff, Catherine. We got Voice says, Voice is bringing in 5 new membos. Oh my goodness, look at all these membos coming in. Paul J, Don D, Danny Law is here. We got Jerry M and Judy O coming in courtesy of Voice of the People. And Voice, thank you for that one. We got Zulu bringing in new membos. Texas Guitar Cal, Jason G, Magic Stick is here. Pitch L, and Scorpid Black Dragon. Man, so that is Zulu bringing in. We got a lot of membos. And so our newest membos, don't forget to go over to the community tab section on YouTube, grab the Telegram link. We'll see you there for our after party. and our members only morning stream. We really try to deliver for our members. We do streams in the morning. We do Saturday shows. And so we're grateful for all of our newest members today. Chris Walney says the Dorfa Jobs merch arrived. The Dorfa Jobs got your 18 US code 242 shirt. Lightweight, looks great, good quality. Amazing, Chris. So Chris, thanks for getting a shirt. Chris went over to robertgovea.com/shop and got the Deprivation of Rights t-shirt. It is good quality. Yeah, it's good quality. I'll start wearing those too. But we tried to really like focus on the quality of our merch store, and it's good. This is all stitched in America, and it's great. By the way, Dershowitz thinks SCOTUS will overturn Colorado ruling. Man, Chris, thanks for that update. And Dershowitz, I think, is right. I hope he's right. I agree. I don't know that they'll let it stand. And thanks for supporting the show with the shirt, Chris. Love that. We got Rocky says, if the 14th applies to the executive, to the president, it must apply equally to each SCOTUS justice. Yeah. I don't know. I'd have to reread it. I never thought about it as applicable to a justice. But yeah, I mean, if it's no one shall hold office, I would say, yeah, it's probably applying to SCOTUS, right? Because they're in an office, which is the highest position in the court. Good question, Rocky. We got Felix says, I don't know if you've covered the amicus brief by former AG Meese filed with the Supreme Court covering Jack Smith's appointment. It's unconstitutional. You're right about that, Felix. And you read our minds. We got that on the show. I hope you enjoyed that segment. I definitely did. I thought it was quite good. And I appreciate you sending in the nice dono, Felix. Thanks for being here, my man. Tony Hay with 5 new membos. We got Andy H, Dear Emily, Scott G, Valerie L, and Yeshua's Healing and Deliverance Minute, all in the house. Good to see you. Thanks for being here, Tony. Thanks for bringing in the new membos. V says, to be honest, I don't like this whole idea that someone can't be voted into office after committing insurrection. One man's freedom fighter is another man's terrorist, and we see what is going on now with fabricated law and charges. Let the people decide. That's the right answer. Let us vote. We can vote. It's like a public jury. We just get to go vote. If everybody thinks Trump's an insurrectionist, he's not going to get voted in. Pinochet's helicopter tour says, cripple the government? Don't threaten a good time, Rob. Well, peacefully and patriotically at the ballot office, right, Pinochet? Debbie Marie is bringing in new membos. What's up, Debbie Marie? Bringing in Samantha R, Nutter Brudder. We got Mr. Null. Maddie's is here, along with the real Kittler is coming in the house. Good to see you guys. Thanks, Debbie, for bringing in the new membos. You rock. We got Maynard has been a membo for 7 months, which means we've got 2 months, and then we're going to have another watcher baby here. Says, is everything Jack Smith has fruit from the poisonous tree? Kind of. Fruit of the poisonous tree is more like an evidentiary issue. But yeah, I mean, I would say certainly, like, if the entire prosecution is invalid, everything that came out of that is invalid. So it goes all the way back from the beginning, all the way back to the root indictment. And that was a delicious reading. Hey, what's up, Tony? Hey, Tony, thanks for bringing in the membos today, my man. Been a member for 8 months. That means next month we've got another watcher baby. Says, hey, what's your feelings on Katie Hobbs sending the National Guard to your border? And do you have any information on what they're doing? No, I don't know what they're doing. I mean, look, this happens every election year. Okay, I've lived in Arizona my whole life. And every election year, somebody does something about the border. Now, certainly, like, we need resources at the border. We've seen the videos here and covered them here mostly on our member streams. But I'm very skeptical that this is a meaningful solution in any way, shape, or form. Okay, Katie Hobbs, we've got election season coming up. They always fake like they're doing something at the border here when things are starting to get political. Primaries are coming up and so on. So I think it's mostly just a fake action that's not going to amount to much of anything. What are they doing down there? Probably helping people fill out forms and get on buses, as far as I could tell. And V says, meanwhile, hardly anyone talks about the legal gymnastics that was used to prosecute Donziger, which I would argue is a precursor to this whole Jack Smith fiasco. Tony Hayes bringing in new membos. BJ Marshall, Darren M. We got Poem P, Terry B. Vientica says bacon, and Tom Seattle all joining us, courtesy of Tony Hay Munkets in the House. Thank you, Tony. Many, many membos today. Tony, you're the man. CF Rob says, basically, Jack Smith doesn't have a federal bar license to practice federal law appointed by the United States Congress. Yeah, he does not. Well, I'm sure he's a lawyer, but I'm saying he's not been appointed, through the regular process. And he's illegitimate. Sandy, what's up, Sandy? Thank you for this one. Says, was Smith chosen due to his specialized work or knowledge of Geneva Convention laws associated with occupation? If Biden is seen as installed via fraud, Smith would have power via law of war manual, occupation section 11. I don't know why they picked this guy. Maybe because, I don't know. I don't know where he came from or what, he has practiced before, right? He's gotten blown out in front of the Supreme Court, but for this position, he was not with the U.S. DOJ. They just went and gobbled him up. So I don't know what the reason was. Now we'll see if they respond to that, and it should be fun to unpack. Thank you for that, Sandy. Knox Bierman is here, says, happy Thursday, all. This admin is great at making up offices. Remember the, quote, office of the president-elect? Yeah, they did that too. And they did that with Obama. I remember that too, they might have stolen that idea from Obama. But the point is, yeah, they kind of make up everything. Your student loans are forgiven. Well, the Supreme Court said no, but they already gave out $1 billion or whatever it was. So good to see you, Knox. Happy Thursday to you. Tony Hay says, I wish Trump would pick one of his sons for vice president. I would also be cool with Sarah Huckabee, and I want a vice president that I'm willing to vote for in 2028. What is your opinion on that? Well, I don't know that a son, I think, would be a lot of Trump. So I think about it in politics, which we should, because it's a race. What do you need to do to win the presidency? You've got to cobble together, you need to pick, I think, a vice president that fixes some of your deficits. So like Sarah Huckabee, I think would be a good one, right? Because I think Trump, generally speaking, has a deficit with women. And so if he could, I think a woman, which is why I'm scared about Nikki Haley, because Nikki Haley is a woman. Like, she kind of checks those boxes that Trump has a deficit on. But, Sarah Huckabee or Kristi Noem or others, could also fill that slot. And yes, I know I am like checking a box. I get that, right? But it's politics, and that's what you do. So I think one of the sons for vice president would be too much Trump, but a Sarah Huckabee would be, not a bad solution on that. And, you might have some like skittish in that camp who would come over. So it's not a bad idea, Tony Hay. It's a good one. Pino Shea says, this clear improper appointment of Smith is further proof that the election, CISA, and J6 were all setups. Government needs to be reined in. Good to see you, Pino Shea. Pino Shea says, if improper, what happens to Smith's work product? Gone. It's all dismissed, but the case is dismissed. And I guess the work product would be, I don't know what the DOJ would do with that. You have to look at like the archive records and stuff like that. But I would say that if I'm a criminal defense attorney, and I am, I would say that anything that was gleaned out of that investigation is inadmissible. Like, we're not going to be pursuing that any further. So I would say it should be dismissed as fruit of the poisonous tree. Debbie says, Ed Meese was born in 1931, part of the silent generation or traditionalist generation. All hail Ed Meese. That was such a good filing, and I enjoyed it. This one came in from G-Gum. We've got a new meme in the house. And our locals friends, we're going to have to reopen another stream tonight, so we're just going to reopen a second stream. Says here, an elf with a twinkle in her eye told me that Santa is very much excited about the gifts he's handing out this year. All right, let's see what this one is. All right, this is your boy here with our Christmas sandals. That's our Joe Biden sandals at robertgovea.com/shop. Every kid who was bad is going to get a Joe Biden sandal. Yeah. Thank you, Jigam. And you made me look a little heavier there, which I appreciate. Look at my hands. They look kind of swollen, which, hopefully it never happens. But that's an interesting one. So thank you for that one, Jigam. And, I do love Christmas, and I do love giving out gifts. The Rubos are here. Says, hit the road, Jack, and don't you come back no more, no more. Hit the road, Jack, and don't you come back no more. Good to see you, the Rubos, in the house. Says, we got Kelly says, I just saw someone mention the Supreme Court denied Jack's cert. Is that right, my friends? Is there any confirmation on that? Let me see if I have any updates from, for example, who's usually good about that? Let's see if Kyle Cheney has anything for us. Justin, Trump says he may go to SCOTUS in another one. No, I'm not seeing it. I don't know. You might be right about that, Kelly. I haven't seen it yet. So we'll see if that's confirmed or not. If it's true, we'll definitely get that tomorrow. We got another one from Tony. Hey, Tony, you're the man. Bringing in Jeffrey, Tazzy Wazzy, Pat H, RAS Illusion, and G Usury is coming in. All courtesy of Tony Hay Munkets with another one. Tony, thank you for those. We got Pinochet says, did the feds control who gets on a federal jury? Well, I mean, you go through like jury selection, right? So, you know, the courts are really the ones who are controlling it. But if you consider the courts to be the feds, then yeah, I mean, the federal courts do. So, yeah. Michael Swade says, can Trump file additional dismissal motions in the D.C. and Florida trials due to Jack Smith's illegal appointment? Yes, I absolutely think he could. I don't know that he will or not, but I don't know if they know that issue or not, but they certainly do now. And it's an interesting one. We've got another one from Glenn. What's up, Glenn? Bringing in 5 new membos. Man, we are going to be flush on our members only stream tomorrow. I can't wait to see everybody. We're going to have Johnny Boy, Mia J, Natasha M. We've got John S. and Linda G all coming in courtesy of Glenn Croy. Thank you, Glenn, for doing that today. Dolphin Fan is the man, is bringing in new membos. Man, it's out of control. We got Crypto Crackheads here. Richard Coffey, Mark G, Beautifully Inappropriate, and Jennifer M, all gifted membos on this amazing, amazing day. We got B-Man says the Supreme Court was not involved with the insurrection impeachment. Well, I think didn't John Roberts refuse to actually preside over that? Wasn't that presided over by a Democrat called, what was his name? I forget what his name was. But yeah, I don't think John Roberts actually presided over that one. We got Spuds is here. What's up, Spuds? Mike and Aaron are coming in. New membo, gifted courtesy of Spuds. And we're going to fire up locals. We're going to fire up another stream right now because our after party is just not going to cut it. So we're going to open up another feed. And it's going to be starting right now. We're getting it queued up. And let's go live. Boom, over there. And so we're going to have to, I think, let's see if I can figure this out. Here is the new link for our locals friends. And then we're going to start this stream as well. So hopefully locals can hear us coming in loud and clear here as well. We got 2 feeds going on locals. All right. So Spuds, thank you for that one. We've got some others coming in, man. Super generous today. NY says, for G-Gum, I want to commission a meme, please. Jack Smith in the Phantom Zone with a Superman and General Zod. It codifies how I feel about Smith and on this great amicus filing to SCOTUS. So Rocky says, Rob, I think yesterday you were reviewing some motion that was defining insurrection by referencing the dictionary. I'm wondering how a Black's dictionary defines insurrection, if at all. So there's a dictionary called a Black's Law Dictionary, and you should be able to just look it up on the internet and see what it says. But I don't know what the definition says or if it's even in there. But it's a good question, Rocky. Knox says, the admin sent federal air marshals to the border at Eagle Pass, and they made sandwiches for migrants and then gave them Uber rides. Radice says, you need Schmedium polo shirts in your merch store. Yeah, like the extra smalls, the Schmediums that I like to wear. That's an idea that we're working on. What would you want on it? Would you want like the Watcher logo? Maybe it's like a polo, something like that. I think that'd be kind of cool. We got Radice. Thank you. We got Sheldon Williams coming in. Thank you, Sheldon. Nice dono. No question on it, but I do appreciate that. STFU says Meese is a beast. This one from Michael Swade says, you should read the 151-page whistleblower complaint against Jack Smith, claiming he was running a blackmail ring in Europe. Totally insane. So I actually have read that, Michael Swade. The reason we haven't covered it here is because it feels it's a little far removed. I would like to see it marinate, matriculate, evolve. I like the story to get a little bit more legs to them. But I did read it. It's like, it's like a whistleblower who's retired from the DEA, who knew somebody who's also retired, is filing the report. And it's far removed. It's probably true, all of it, but it's pretty far removed. John McGarvey says, could Trump sue anyone that turned over his records improperly if Jack Smith is found to be illegitimate? Well, I would say that Trump had his constitutional rights violated. Okay, so Trump has actually been harmed, and he deserves damages from a corrupt, illegitimate government that violated his constitutional rights. He should be able to sue for damages and recourse and get everything back because it was all illegally constituted. I'd like to see it. We got this one from Tony Hay. Tony Hay is bringing in 10 new membos, including Nigel, Yorick, Jamar. Stop sniffing kids, Joe is coming in. We got Peng, Salty, TJ Hartley, Veg Scroll Bloom, Johnny Commodi, and Mark L. all coming in courtesy of Tony Hay Munkets. Tony, you're the man. Adesia says, Rob, you move so quickly. Well, we got to go fast, man. We got an after party to attend to. And Spuds is saying, with friends like Nikki, you have no friends. And so, my friends, those were very generous donos in the house. I'm super grateful for those. Thank you for sending them in. Thanks for inviting all the membos in. And membos, don't forget to grab the Telegram link on the community tab section, because that's where we're going right now for our members only after party. As soon as we say hello to X, we got 40 viewers, man. 40 viewers on X, out of control. So nice to see everybody. Thank you for joining us over there on the X platform. And let's see who else we got coming in. We've got, says here, that was the finest amicus brief you've ever read on this show. I was very happy about it too. Rob, I've said this from day one, super chatted about it, but the special counsel has to be a U.S. attorney. No one ever listens to me. The fashioning, well, you're right about that one, Fred. Sounds like a pretty good one. And this word ex nihilo says the fashioning of life ex nihilo by God. All right. That's what that word means. Hatman says, sorry, Rob, I stopped watching these kind of shows. Oh, that's too bad. So you make valid rule of law points, but the rule of law in our country no longer matters. The rule of law is dead. Well, it feels like it's, changing for sure, but there will always be the rule of law, whatever the law is. There's always going to be somebody ruling something, and they're going to have some law. So we're kind of wondering what it is. And I'm not willing at this time to acquiesce to the end of America. I think that even if the end of America comes about, whatever that looks like, there is a fight for justice that must be preserved no matter what. Even if the country changes, justice still matters. And I'm for living in a society with justice. And so we're going to keep staying engaged here. I understand not wanting to watch a show like this because it's kind of heavy, but from my perspective, we have to stay engaged. We have to stay connected because we have to save our society. Ronnie's here. What's up, Ronnie? Robert's here. We had, Jack Smith, not legally appointed. Al Holman talking about in the documents case. Says if any agency of the government provided information, that was not requested by the president. Life without paroles here. What's up, Life? Mayday is saying here, is Jack Smith even his legal name? It sounds fake, doesn't it? It would be great if that brief results in the case being thrown out, says Adam. TJ King is here, and Lala Sunshine is also here, talking about the bite of the poisonous apple. And so, my friends, thanks for joining us over on the X platform and saying what's up. Our follow account is at Rob Govea ESQ, and we have a watchers community that looks like this. And so here is what that looks like. So certainly check that out. Now, we also are going over to watchingthewatchers.locals.com for our members only after party. And so we hope to see you there. We do members only streams in the morning. We do Saturday shows, and we'd love it if you came and joined us. We'd also want to send you over to our website, robertgovea.com. We've got our brand new shop which is alive and well. You can click this button right here, get the flip-flopping Joe Biden sandals, get the Watcher hat, get the Deprivation of Rights t-shirt, get the Ungovernable t-shirt, get the Hillary Clinton flip-flops, get a gift card for somebody if you're looking for a Christmas gift that you haven't gotten yet. Just get a gift card and they can get something themselves. And so check it out, robertgovea.com/shop. But that, my friends, is it for us. Before we leave it there, we want to say thank you to our mods and our meme smiths, including Zach Nichols, who was clipping a lot for us today. Vienticus Prime clipping a lot for us today. We're grateful for you both. And so shout out to Vienticus, shout out to K-Bean, Just Cause, Playin' Hooky, Ronnie Cole, Zulu, Beyond Geo, Zach Nichols, John Allen, Janek909, Dog Digger, and of course, Donut Mind Me. And so, my friends, thank you to our meme smiths. We saw the beautiful new one from Geegum Geegum today. Christmas Carol Rob handing out Hillary Santals. And Sleepy Dog Lee, thank you, Geegum, and Nathan N810. But my friends, that is it for us on the day. We covered a lot of ground today, and I want to thank you for the very generous donos, all the amazing members. Thanks for bringing everybody in and joining us. It's going to be a wild year, and we are looking forward to it. We're going over to our members-only after party right now. We'd love to see you there, but if not, well, we are going to see you right back here tomorrow so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night, my friends. Sleep very well. I'll see you right back here tomorrow. Bye-bye.